All rise. Please be seated. Well, good morning. As usual, lots of familiar faces. Welcome to everyone. The court is in session again, and we will resume oral arguments. The court has received the new schedule with the new subjects. We suggest to start at 1 o'clock, 1 p.m. on Wednesday afternoon. And the court also assumes that we'll wrap up on Wednesday. Friday has been reserved so far, but I assume that we won't be using that hearing day on Friday. Having said that, you have the floor. Thank you. President of the court, members of the bench, prosecution, ladies and gentlemen. Today consists of a morning section and an afternoon section. In terms of our oral arguments, I shall argue during the morning, and I suppose that will have a brief break. And I will continue until the break. Indeed. So 2 sections, as I said, up to lunch. And in that section, we want to talk about an alternative scenario. And after lunch, Mr. van Eyck will continue with evidence question 3. But first of all, an alternative scenario. My first page is missing. So I have my page here. Over the past few days, we argued that it cannot be proven that the missile causing flight MH17 to crash was a book missile. And if it turns out that flight MH17 was downed with a book missile, it cannot be proven that flight MH17 was downed with a missile that was fired from a field near Pervomaisky. That it was not the book tailor that was possibly in the area of Schnitzne. We have explained with sufficient reasons and arguments why the evidence supplied, even if it were lawful, cannot provide sufficient certainty, insufficiently qualifies, and or is insufficient conclusive for as evidence for evidence question 1 and 2. So there's insufficient conclusive evidence to determine with a probability bordering certainty that flight MH17 was downed with a book missile 9M38 or 9M38M1 launched from a field near Pervomaisky. If we cannot establish with sufficient certainty and inclusively that the events transpired as charged, then there should be an acquittal. This does not require that we determine what did happen. And that from the perspective of law of evidence, this is not necessary. That does not, however, mean that it's not relevant to find out what may have happened. Quite the contrary. For several reasons, it is of the utmost importance to find out what did in fact happen. First of all, it's clear why lots of people have a big interest in finding out the truth. Finding out the truth is important for the relatives and other interested parties who've been hoping for clearer explanations for years and expect a great deal from this trial. A number of these relatives, a large number of relatives, may have thought that over the past few years they, in part, perhaps understood what transpired. And we understand that what we've been arguing over the past few days, showing that even that clarity, unfortunately, does not exist, that was not what everybody wanted to hear. And also in view of all these people that really want to know what the truth is, therefore, there is an interest in finding out what could have happened. Finding the truth is also necessary in order to hopefully prevent this from ever happening again. This has been the reason for our client, and still is the reason for our client, to make a contribution to this trial, amongst other things, by requesting us to request on his behalf many investigative measures that could possibly help reveal the actual course of events, or that is what he hoped in any case. There's a page missing again. That this is not necessary in terms of the law of evidence doesn't mean that it's not relevant. No, I'm sorry, I'm repeating myself. Where was I? Paragraph 7. Yes, I was explaining why this is relevant. And thirdly, also from a legal point of view, there's an interest and a relevance in finding what did transpire on 17 July 2014. And this is something we need to explain a bit more, because I just argued that for acquittal, it's not necessary to have a clear understanding of what happened, only not what did not happen. The reason why, for the defense, from an evidence law perspective, it is important and relevant is in case your court should not agree with the conclusions put forward by the defense. In other words, if your court should find that lawful evidence is qualifies sufficiently and is conclusive enough, and should your court find that based on the available evidence, we can establish with sufficient certainty that flight MH17 was downed with a Buk missile that was fired from a field near Pervomaisky. In that case, in this unexpected event, then the legal question arises whether another scenario would also be possible in view of the evidence that is available. If another credible and not implausible version is possible that is not at odds with evidentiary means, but is incompatible with declaring the charges proven, even if in that case there could be sufficient potentially conclusive evidence, even then there should be an acquittal. Many people will think an alternative scenario. Excuse me? How? The public prosecution and the JIT have investigated everything already. That may seem the case, but it's not the case. A lot, even though not everything, but a lot that could theoretically show whether a Buk missile was launched from a field near Pervomaisky was investigated. But that different scenarios have not or hardly been investigated. And the prosecution not only says that not only the main scenario has been investigated, but that also alternative scenarios have been investigated and ruled out. But that's not really true, not really. Some investigation has been conducted into alternative scenarios, but just marginally. And the only purpose seems to have been to rule out this scenario. It doesn't really seem to have been focused on the question whether it was really an option that there could have been a different scenario. And I would like to refer to what we put forward in our pleading notes earlier on. This goes to show that a lot of the investigation could be predicted with the answer that the MH17 was downed by a missile, a Buk missile, that the formulation of the question that was raised often was such that there could be no other answer than that it was more or less probable that it was a Buk missile near Pervomaisky, that any investigative measure into an alternative was preceded and followed by a multiplicity of investigations into the main scenario. Counterindications of the main scenario were ignored or reasoned away, whereas support for the main scenario was embraced. In view of the way in which the JIT and prosecution have approached and carried out the investigation by making every effort to seek confirmation for the main scenario on the one hand and easily accepting to dismiss counterindications for the main scenario on the other hand, it's no small miracle that the prosecution's conclusion was that confirmation has been found for the main scenario and that the other scenarios have been ruled out. However, and this is what I'll be discussing now, it says this means very little. Despite all the energy that has been invested in ruling this out, there is one specific alternative scenario that I will call the Ukrainian missile scenario. There is one alternative scenario that is not being ruled out by the results put forward by the prosecution and that is not at odds with the lawful means of evidence. The prosecution in June 2020 explained why it believes that another missile other than a Buk missile can be excluded and that if flight MH17 was downed with a Buk missile, there could have been no Ukrainian Buk missile fired from the vicinity of Saroshenko, so that cannot be the case. I quote, according to the public prosecution, there could not be any other surface-to-air system because, based on the analysis of forensic findings in combination with the weapon systems present in the region, would point to no other Buk system in the region and no indication was found that could be further investigated. We have already discussed this reason and other reasons on the basis of which another SAM service-to-air system was ruled out, and the incorrectness thereof was also discussed when we discussed evidence question 1. I refer to that, and I request you to consider this to be incorporated in my pleading notes. Conclusion of the public prosecution that there could be no other launching area is based, amongst other things, on the allegation that there are no specific indications for launching a surface-to-air missile in one of the other locations that could be possible if we depart from the range of a Buk tailor, and the range, according to the prosecution, is 36 kilometers if we then look at the last known position of flight MH17. In other words, based on the range, other locations as such could be possible, but they did not become apparent according to the prosecution. And before I discuss the specific indications that, according to the prosecution, would be lacking, would be absent, I would like to highlight that the Zherosensk area is well within a radius of 36 kilometers of the last known position of flight MH17. Prosecution and the defense agree on one point that has been described by the prosecution as follows. Technically, it was possible to down flight MH17 from this location with a Buk missile. Although the prosecution subsequently points out that according to certain sources there are or may be indications for the area around Zaroshensk as a launch area, this, according to the prosecution, can be ruled out as a possible launch site because A. The satellite images, unlike what the Russian authorities have said, you cannot see that the Ukrainian Buk tailors were moved there. B. This would be outside the launch area calculated by NLR and RMA, and C, because the investigation would not have led to specific indications thereto. Furthermore, prosecution says that it investigated the possibility that the Ukrainian armed forces downed flight MH17. There's reference to the investigation that I just summarized, A through C, as well as the investigation into D, Buk systems of the Ukrainian armed forces, E, origin of presumable missile parts that were found in the forensic investigation, and F, the question who controlled Zaroshensk. I will discuss the grounds put forward by the prosecution to exclude a different launch area. And first of all, I'll discuss A, which is satellite pictures. the public prosecution discusses in detail why the satellite pictures as provided by the Russian authorities would not prove that the Ukrainian book tailors were moved from a base northwest of Donetsk on 17 July 2014. The satellite photographs, according to the prosecution, have a different date. According to ESA, furthermore, from 17 to 21 July 2014, there was almost a full cloud cover in this area, as a consequence of which there are no satellite images that are available. Assuming the ESA findings are correct and that there was no satellite image of 17, 18, 19, 20, 21 July 2014 of that area, so assuming the ESA is correct, the satellite images therefore cannot provide us with a proper answer to the question what exactly happened on 17 July 2014 in the area of Zaroshensk. This, by the way, by analogy, applies to the JIT field near Pervomaisky. There are no satellite images of that area in the period between 16 and 20 July 2014. And just as with the satellite photographs of the area of Pervomaisky, we can look at the satellite pictures of the Zaroshenska area, the period after 2021, July 2014, which is exactly what the prosecution did. They looked at satellite pictures of 21st of July 2014. Their conclusion is that no traces can be seen of a launch or a launching vehicle. Whereas, should there have been a launch, there may have been a fire and caterpillar tracks would leave marks. This conclusion has all the characteristics of an easy conclusion, a shortcut. The fact that on one field there were no fire or track marks may rule out this one single field, but it does not rule out many other fields in that area. The area south of Zaroshensk, which is the area that Almas-Ante marked as a possible launch area, is not this one single field to which the prosecution apparently limited its investigation. The Almas-Ante press conferences referred to by the prosecution when they mentioned this one field, this one area. At this press conference, an area was shown of 2.2 by 2.5 kilometers south of Zaroshensk. They didn't show one single field. As far as we know, it was never investigated whether in that area there was no one single field with black patches and or track traces. So that in any case cannot be ruled out. Furthermore, we already discussed that the presence of a black patch and track traces are meaningless because these traces can also be caused by other causes such as combat or agricultural measures. It's more important in this connection, just as the presence doesn't have to be telling, the absence doesn't have to be telling either. It is quite possible that there may be a launch somewhere, but that there are no visible traces that are visible on a satellite photograph. If a launch takes place on sand, terrain with little shrubbery, there doesn't have to be necessarily a fire, and track traces will be less visible.
The point that I just mentioned is B, the launch area calculated by NLR and RMA. The prosecution asserts that Zaroshensk lies outside the launch area calculated by NLR and RMA. Regarding our evidence defense, we've provided a lengthy, substantiated explanation of the shortcomings of these calculations, as well as an explanation as to why the calculations by Almas-Ante, supported by the U.S. experts, are far more reliable and credible. The conclusion that the Zaroshensk area is not outside the launch area calculated, but on the contrary, unlike the area of Pervomaisky, is inside the most convincingly calculated launch area, has also been explained. The other investigation by the prosecution would not have indicated, said not to have indicated Zaroshensk as a launch area. Remarkably, the prosecution, as mentioned earlier, did not look beyond that one field. If they had looked in the area of Zaroshensk, that might have provided indications of black spots and or track marks. The conclusion that the prosecution reached that other investigation provides no indications, mainly revealed the shortcomings of the investigation that was conducted. According to the prosecution, its investigation basically involved taking soil samples, looking for witnesses, open sources, and telecommunications data that could confirm Zadoshensky. That research operations will be discussed. It is remarkable that the prosecution mentioned the soil samples as investigation to an alternative launch site. The soil samples taken were not even examined, so we have no way of knowing whether, if the soil samples had been examined, they could have provided an indication for a launch location in that area, especially if the soil samples had been taken earlier. The prosecution says this was possible only in June of 2015, but especially with respect to that area, it's not substantiated. Apparently, the JIT saw the Zadoshensky area far earlier as a possible launch area, nor does the record show that this area was inaccessible for investigation by or on behalf of the JIT. The indications that they could have provided for a launch area would have been more realistic if the soil samples had not been taken only in a single field. In the record, we did not find why this was done only in one area, but whatever the reason, it would appear that all other fields from the area indicated of 2.5 by 2.2 kilometers in the Zadoshensky area, it appears that no soil samples were taken there. Suppose the JIT had wanted to take soil samples that could have yielded something useful, then they could simply have asked Almas Ante for the coordinates of the launch area they had calculated to take more soil samples and then subject them to additional investigation. So it is not surprising that the soil samples provide no indication for Zadoshensky as a launch area. After all, at only one location, 1 year after the fact, were soil samples taken and they were not examined. That these or other soil samples would confirm or rule out a launch area cannot be ruled out, especially if more soil samples had been taken in time or in several spots and had been examined. That the JIT overlooked the opportunity to find, based on soil investigation, indications that a missile was launched from the Zadoshensky area is not cause to conclude that the area was not where the launch took place. Witnesses are another part of that investigation. The prosecution asserts that despite repeated calls, no witnesses approached the JIT that confirm a launch from Zadoshensky. Which repeated calls these are, and the wording is not mentioned. In November 2020, we asked for additional information about this, information that, as I quote, reveals how, where, and which witnesses were sought, and if found and interviewed, the reports of these interviews concerning the launch location topic. No response was provided. If the prosecution intends those repeated calls to mean JIT calls for witnesses, these can hardly be regarded as appeals for witnesses able to confirm a launch from Zadoshensky. The witness appeals that appear on JIT's website explicitly target the crew of the book Teller and persons who were an important link in the decision-making in the Russian Federation and comparable formulations. That's not a search for witnesses able to confirm a launch from the Zadoshensky area. It's a search for witnesses able to confirm the JIT scenario. That in relation to such calls, no witnesses showed up that would have been able to confirm an entirely different scenario is not strange, especially given the presumably unsafe climate in which those witnesses were. It cannot be inferred that these witnesses are not there and do not exist. Apparently, the prosecution does not want to go so far as to say that no witnesses exist who could confirm a launch from Zaroshenskoye. The prosecution says that no witnesses showed up that could confirm a launch from Zaroshenskoye. Nobody says that the launch itself was from Zaroshenskoye. We don't either. The area of Zaroshenskoye is a different story, and the explanation from the prosecution allows for the possibility that there are witnesses, and the witnesses even showed up, who could have confirmed a launch from the area of Zaroshenskoye. So the question is whether such witnesses showed up and whether they were interviewed, and whether there are reports of that in the case file to which we do not have access. It cannot be and is not ruled out. Moreover, if no witnesses showed up, this does not mean that much. No witnesses showed up from Perfomaisky, either confirming a launch from that area, but that did not prevent the JIT and the prosecution from concluding that a missile was launched from that area. And that from Perfomaisky, which has a population of about 2,830, nobody showed up as a witness to a launch that is said to have taken place right next to that village is more remarkable than that nobody showed up as a witness to a launch from the area of Zaroshenskoye. According to Wikipedia, since 2001, Zaroshenskoye had only 14 inhabitants. The likelihood that one of those 14 shows up as a witness is by definition minimal, especially with respect to the likelihood that somebody would show up from Perfomaisky. Specifically because the Zaroshenskoye area is so sparsely populated, it is perfectly possible that a launch could go unnoticed there. Aside from the 14 inhabitants of Zaroshenskoye, apparently somebody appears to have shown up who says he or she has information about a book system at Zaroshenskoye. The prosecution mentions a Ukrainian former major in this context. We did not find the interview mentioned with him in the case file. The prosecution's primo listing states not incorporated, so we can't say very much about him. But the prosecution indicates that they saw no reason to interview him. If you decide not to seek and not to interview witnesses, then you can't get confirmations from witnesses stating that a missile was launched from the Zaroshenskoye area, nor can you consider that cause to rule out a launch from there. And the prosecution notes that the Ukrainian combatants had missile systems. So this is the item about the book or other missile systems of the Ukrainian armed forces. The prosecution notes that the Ukrainian combatants had book systems, but that the fixed locations were were beyond the range of the MH17. The prosecution rightly indicates that this does not reveal so much because those systems can be moved. Previously, I mentioned that in 2014, the Ukrainian combatants had 27 tellers and at least 157 book missiles. The case file also reveals that in 2014, prior to 17 July, there were dozens of displacements of Ukrainian book missiles in East Ukraine. The prosecution further indicates that the Ukrainian military, according to the chart provided, did not fire book missiles in the East Ukraine conflict in July 2014. The question is how much value should be attributed to this? Not very much in our view. Of course, the armed forces say that they did not do this, nor is the assertion that no book missiles were fired substantiated. The chart that the prosecution mentions as a source for this assertion reveals that Ukraine does not say that Ukrainian armed forces did not fire book missiles in East Ukraine. The chart the prosecution is referring to concerns a reaction from General Karpenko to a question from the SBU, indicating a comment about surface book M1 surface-to-air systems, which in the answer are consistently referred to as book SAM systems. The general is saying that when he mentions a book SAM systems, he's talking about a book M1 system, according to the general. The memo referred to concerns only M1 to 9M38 M1 book type, the new type, not the 9M38 book missile type. So it's incomplete and incomprehensible that the Ukrainian military was exclusively asked for information about the new type of book missile. The SBU appears to have asked that question on 9 November 2015 based on the response to it, which is a bit more than 6 months after the casing was found. The casing is from the old missile type. Why were no questions asked to the Ukrainian military about the availability and deployment of that type of book missile? Regarding the new type of book missile, which are described as relevant in the chart. For example, the Ukrainian military was asked about the condition of the available book systems, plus which part was used or available during military campaigns on 17 July 2014. And these questions, and there were several of them, the answers mentioned only which book systems of the Ukrainian military were combat ready on 17 July 2014. According to that chart, 18 tellers were combat ready on 17 July 2014. The other part of that question, so which part of the available books systems was used at that time, remains unstated and unanswered. The Ukrainian military did reveal something about the new type of book missile launches in the first half of 2015. Around that time, the Ukrainian military, according to the chart, launched 16 new type book missiles. As stated, the answer from this general concerns only questions about the new type of book missiles. The answers to the question, which according to this general was not asked, to the question that was of how many book missiles of the new type were launched on or after 17 July 2014 is not answered. Therefore, unknown whether book missiles of that type were launched in that period, but we do know that the Ukrainian military was using that type. So we know that 61 of those book missiles of that type were transferred from one military base to another. The chart also mentions annexes in which are said to include the old type of book missiles, but those annexes are missing. That many old type book missiles were being used, were transferred, but that not one of that type of book missile was launched is not plausible, especially given that 16 of the new type of book missile were fired. So why not the old missile type? The suggestion frequently heard that Ukraine had no reason to launch book missiles because DPR combatants did not have fighter jets does not answer that question. After all, there are other reasons to launch book missiles. Book missiles also serve to intercept other missiles, and the DPR military had and used other missiles. Besides, the fact that 16 new type book missiles were fired reveals that apparently there were reasons to launch book missiles. So, Ukrainian combatants are known to have had many tillers and far more book missiles, that there were many movements of them and transfers, and that many of them were combat ready on 17 July 2014, and that 16 of the new type of missile were fired in the period from December 2014 to June 2015. How many old type book missiles were available and launched was not asked, was not listed, is not known. So whether the Ukrainian military launched an old type of missile on 17 July 2014 is, aside from the value, but unlike what the unlike what the prosecution is asserting, was not investigated or refuted. So the assertion by the prosecution that the that stated chart reveals that the Ukrainian military did not fired such a missile in July 2014 should therefore be set outside as unsubstantiated, not plausible. Moreover, we know nothing about the question as to which other types of missiles were in the arsenal of the Ukrainian forces or were in the neighborhood, let alone whether such missiles were fired. As far as is known, no investigation was conducted about this.
Now, the prosecution also refers to the origin of missile parts that have been found. Now, the prosecution talks about various parts of a Buk missile that may have been from an IM-38 or an IM-38M1. Now, one of the parts found drew quite a lot of attention. That is a casing, because that part had a kind of a calling card on it in the form of a unique number. And that number indicated that it was part of a missile of the older type that was delivered to an army unit in the 1980s, an army unit which is now part of the Ukrainian army. Now, the prosecution also refers to gaps in the Ukrainian army's administration, in light of which it does not seem that the missile was not returned after it, from which it does not seem that the missile was not returned after it was dispatched to the army unit that now belongs to Ukraine. However, there is also no indication at all that the missile was ever returned. The Ukrainian authorities don't claim that either. The Russian authorities have shown that the casing had been delivered to an army unit, which is now part of the Ukrainian army, and Ukraine has not been able to show that that missile was not in their possession in July 2014. Only that missile could not be found in their administration, but most of their administration was either absent or had been destroyed. Now, I dealt with this topic in detail when rebutting the evidence relating to question 2, and I would refer to that. Now, the conclusion regarding the casing is that a casing has been found which is related to the old type of missile, and that was a missile which belonged to a unit of the Ukrainian army. Now, this does not necessarily mean that MH17 was downed using that particular Ukrainian Buk missile, but it is possible, and the casing is certainly not a reason to rule out the alternative scenario. In fact, it could support it. And now the prosecution also claims that Zaroshchensky was under DPR control, implying that the Ukrainian army would not have been able to launch a Ukrainian Buk missile from the Zaroshchensky area. Now, the prosecution bases its view that Zaroshchensky was under DPR control based on statements by journalists who said that they had heard it from residents of Zaroshchensky. Now, as far as we know, no such residents have been interviewed as witnesses by the JIT. The prosecution also refers to 2 intercepted telephone conversations which took place in June 2015 involving a commander. Apparently, during these conversations, they discussed the fact that Zaroshchensky was under the control of the DPR in July 2014. Now, neither the commander nor the person he was speaking to during those conversations has been interviewed as a witness by the JIT. So we can't know what was said by residents to journalists or what the commander might have said during the telephone conversation. And one fragment of that of one of the 2 intercepted telephone conversations carried out by the commander was actually played in court. But later in that same conversation that was intercepted, he says that the DPR did not have a functioning Buk tailor, but rather the booktailer that was in the DPR on the 17th of July 2014 was not a functioning one, but rather a mock-up. Furthermore, a telephone conversation which took place 1 year after the downing of the MH17, in which it was said that Zaroshenko was under DPR control, does not actually mean that the vicinity of Zaroshenko was not under their control. So the question as to who had control over the surrounding area of Zaroshenko is not covered by what the commander said in that telephone call. Now, a general from the Ukrainian army was consulted by the JIT on who was in control of that area. It was the SBU who questioned him. The general, however, responded to the question by saying that the information was outside the scope of his expertise. He sent a letter dated the 9th of November 2015 recommending that the ATO be contacted for information of that type. And the ATO is that part of the SBU that was acting against or tackling the DPR, which they consider to be terrorists. There is also a report in the case file in which the SBU has, or it contains a map produced by the SBU which shows what areas were under the control of whom on the 22nd of July 2014. It is not known what the basis is for this map, which was produced by the SBU. Now, the SBU map does not align with reality. It indicates that the area of Zaroshenko was under the control of DPR, but that is highly controversial, and that map is controversial. On the 17th of July 2014, the area around Zaroshenko was not under DPR control. The front lines could not so easily be mapped out. There were separate bits and pieces of land that were under the control of one or the other party. Some of those pieces of terrain linked one to another. But that was not the situation around Zaroshenko. A Russian cartographer mapped out the situation in eastern Ukraine and also the surrounding area of Zaroshenko, and he described it as follows, and I quote, "Rebels held a defensive line practically along Donetsk, Shatovsk, Snezhia. The defense was of a focal and non-continuous nature, so the columns of Ukrainian armed forces traveled sufficiently freely within the surroundings of settlements and could have relatively easily traveled through all rebel-controlled territory through the fields from north to south, just like happened in the attempted assault of Shatovsk on the 27th of July 2014. The Zaroshenko village was not an important stronghold for either side. It is not mentioned in the reports, and it is located on the territory on which Ukrainian armed forces traveled freely. Analysis of the situation in the vicinity of Zaroshenko is also possible based on the description of fighting which was given by residents of the area and which can be found in open sources. Now, quite a comprehensive description and analysis of that type of information can be found on the website of a witness whom the JIT interviewed. And based on that information, it emerges that Zaroshenko, or the Zaroshenko area, was not under the control of the DPR. Now, I would have liked to have shown you that map produced by that witness. I'm afraid I can't project it now, but what I can tell you, it's in my file notes, and what I can tell you is that you can see the Zaroshenko village on it, above a blue line. Then we have yellow circles surrounded by a blue line with a cross on them, which indicate Ukrainian checkpoints. Then there are red circles with a red cross through them, and there's the DPR checkpoints. And the area to the south of Zaroshenska, which in fact is the area which was calculated as being the possible launch area by Almaz-Antey, falls in an area, or lies in an area, which was entirely accessible to the Ukrainian armed forces. Now, I'd like to draw a first conclusion. And that conclusion is that, and I would refer you to my pleading notes regarding part 3, but the conclusion is that one cannot rule out that another or a different surface-to-air missile, other than that suggested by the prosecution, was fired. Now, the prosecution claims that there are no indications for the launching of a Ukrainian Buk missile from the area south of Zaroshenska, but in fact that is not supported by the content of the case file. Rather, in the case file there are indications which would support such a scenario. For instance, we have the calculations made by Almaz-Antey, which indicate that if MH17 was hit by a Buk missile, that missile can only have been launched from an area south of Zaroshenska. And of course, we have the fact that that Ukrainian Buk missile casing was found. Contrary to what the prosecution says, the Ukrainian missile scenario cannot be ruled out. The Ukrainian armed forces, after all, had full access to the potential launch site south of Zaroshensko. They also had Buk telars and they had Buk missiles, which were being moved around and were combat ready, and which were firing Buk missiles. In the letter from the Ukrainian army regarding information on Ukrainian launches, it is not apparent whether on the 17th of July 2014 a Buk missile was fired. But we need to know that this area south of Zaroshensko is very thinly populated and that it would be unlikely for there to be witnesses in any case. So there is no evidence to indicate the contrary or evidence that rules out the possibility that of a Ukrainian Buk launch. In particular, it is not true that the area was surveyed for traces of fire and for tracks produced on the 17th of July. I think we can take a break here, and the presiding judge suggests that we break now until 11:15.
All rise. Please be seated. Court is in session. We're going to proceed with the rest of the arguments. Thank you. There's also an annex that belongs with this, but it is being printed as we speak. So I'm sure we'll receive it in a moment. In the course of this section, it'll be brought in by staff of the court. Otherwise, we'll give it to you after the break. So, I finished with the Ukrainian missile scenario that it cannot be ruled out, even though it may seem as if everything else has been investigated and that it's simply not possible that something else happened, something other than what the prosecution believes. The defense's position is that another scenario was never really properly investigated. Based on the JIT investigation, one cannot say that other scenarios, in particular the Ukrainian missile scenario, were really excluded. In any case, nothing that shows that it cannot have been a Ukrainian missile or Buk missile fired from the area south of Saroshensk. That's what my pleading notes should say. Could you change Pervomaisky in Saroshensk? I'm not only saying this to make a point and to make way for an alternative scenario. I'm also saying this because this, for us, was the reason to continuously question the case file that we have in front of us and to question the conclusions of the JIT and the prosecution. We have not, based on the investigation that has been conducted, we have not been reassured that things could not have happened any other way. In the more than 2 years that we've been working on this case, the question how flight MH17 was downed was always top of mind. And we, just as everybody else in the Netherlands, saw the press conferences, the animations, the endless repeated, we know for sure, of the JIT and the prosecution. We saw all that. And up to late 2020, we had no reason whatsoever to doubt those allegations. And before we received the case file in 2020, we said to each other, if indeed it is established that flight MH17 was downed with a Buk missile from a field near Pervomaisky, then it is what it is. We're not going to argue against all odds. Then the question is whether our client was criminally culpable or not. But at no time did we receive that certainty. And the more we came to know about the case file, the more the conviction created by the press conferences diminished. And we increasingly wondered whether something else could have happened. That we were not convinced that things happened as the prosecution says, and we have not been reassured that nothing else could have happened. All that is in part due to the one-sidedness of the investigation, in which confirmations were embraced and counterindications were either ignored or reasoned away. Another reason why we have simply not been able to resign ourselves to the main scenario of the prosecution is that there are simply too many pieces of the jigsaw puzzle that don't fit. And I'm referring to the evidence that is at odds with the main scenario, as discussed in connection with evidence question 2. But also, and particularly, questions that also based on the main scenario of the prosecution, even if that scenario were to be fully correct, questions that remain unanswered. Nonetheless, why would a tailor be positioned or even deployed in that field near Pervomaisky? What would the purpose could have been? What could the instruction have been of the crew? Why would the crew have fired the missile? And what did they think they were targeting? Why did they launch the missile so incorrectly? What went wrong? How come? The case file doesn't answer any of these questions, and the prosecution said in 2020, in June, the investigation so far has not been able to provide a definitive answer about the reason why MH17 was downed. The public prosecution's address doesn't provide any answers either. Prosecution in June 2020 tried to interpret this when they were still implying that the crew must have thought that a military aircraft was approaching. This so-called error scenario was not substantiated or made plausible by the prosecution in any way. Nothing shows, for instance, that there was a military aircraft that was approaching that could have led to this error. Nothing shows that anybody could have thought that a military aircraft was approaching. For instance, there's no telephone conversation whatsoever in which a spotter communicated that there was a military aircraft approaching, or a telephone conversation with the instruction to launch. And the investigation into these, in inverted commas, the crew, even after 7.5 years, shows nothing that could be relevant for this case. Assuming that the prosecution now does indeed understand that it's important that an order to launch be given, and if so, what that order was, and that there was a reason to launch and to order the launch. And since we don't have that information, the conclusion is that all these questions are still pending. We still have no idea why a booktailer would have been positioned and deployed at that location, why a crew pushed the button at that point in time, what the crew intended to strike, and how things could have gone so terribly wrong. The prosecution says that the answers to those questions don't make a difference for the matter of evidence. The point is that the missile was launched from that field, according to the prosecution. But it's precisely those issues that make a launch of a book missile from that field in the direction of flight MH17 so improbable and implausible. So those answers do matter a lot. What we do know is this. The case file irrefutably shows that a teller can and shall only be operated by trained and professional crew. The commander has to have finished a 5-year training and has to have the degree of engineer. And a teller is then generally deployed in a battalion position, i.e. with several vehicles, but can, and this is an exception, can also function autonomously. An autonomous tailor can operate either in a standalone or in an ambush mode. In the standalone mode, a senior commander, so someone outside the tailor, will take a decision based on the information of the crew about the target and on whether or not to launch. There is no clear communication with a higher commander during the deployment in the ambush mode, in which either prior authorization is given for a launch on a specific target with specific parameters, or action is taken following up on other intelligence, for instance, of a spotter. The Ukrainian former army man and experienced book user RCO2, consulted by the JIT and questioned by us, explained that no one would ever veer from the orders. He says, a battery of a launch installation consists of highly skilled staff that cannot do anything without the top army echelons being involved. The officers can receive the order beforehand or in situ. There is a strict hierarchy that is followed. Irrespective of the action mode, a procedure will always be followed before launching. And if the tailor picks up on a specific target, the commander will automatically do an IFF query in order to determine whether the possible target is friend or foe. Friendly and enemy targets are distinguished on his screen. In the case of a friendly aircraft, the switch can be turned with which he can disable the automatic launch locking device. These targets can no longer be passed on to the teller. All these are words from a primo from the case file. Furthermore, the teller commander, within 5 minutes after locking, will carry out a second identification procedure. The procedure consists, besides the automatic IVFF query, will consist of 2 parts. First of all, he will listen by means of the loudspeaker in his tank cap. He will be listening to the sound of the approaching target. And then he will instruct the teller to identify the type of target based on the reflected radar image. The commander will then check the other features. And the official record case file weapon says the following. After finding the target, the teller also shows the altitude, speed, distance, and course parameters in meters. This information, along with the blip on the BPI, will provide information on the nature of the target. Based on the sound and the identification by the teller commander will activate a switch that will distinguish a propeller, ballistic, or rotor aircraft. The corresponding flight path is then forwarded to the missiles. The second operator will then check whether the target is in view of the TOD so that a visual identification is possible. The battalion commander will monitor everything on his PPI and the switches in the CP. RCO2 also makes a statement to that effect. He says, furthermore, it is an incredibly complicated system. A simple mine worker cannot operate the system. Operating a book system in the field is much more complicated than operating an aircraft, even modern aircraft. The investigating judge then asks him whether he knows that when deploying a book system, this strict hierarchy is always followed, and then he answers, yes, without veering from the order. I was a commander of the battalion, and I can say that an order is given, a target is specified. A target is given based on time, speed, altitude, azimuth, and this instruction, this order, can only be given by a commander of a brigade. It is absolutely inconceivable that the order be given by some mine worker or other. And later on he adds, I meant to say that a commander of a tailor will never shoot a target that in terms of parameters and basic data differs from the basic data given. Altitude, speed, azimuth, these are the basic data that he needs to receive in order to detect a target. Otherwise, the commander will not act. An order or instruction is given, and you act within the context of such order. In short, only in accordance with the order and after extensive checks to see whether the potential target indeed is the intended enemy target based on several typical features, a trained crew led by a commander will proceed to a launch. The public prosecution argues this away by acknowledging that those pieces of the jigsaw puzzle are missing, but by arguing that these jigsaw puzzles are simply not necessary in order to assess this case, quite apart from the fact that these jigsaw puzzles are needed in order to answer evidence question 3, and I'll discuss that later on. The prosecution fails to recognize an important part of the problem. These pieces of the jigsaw puzzle are not only missing, they simply don't fit. It's not just that for some mysterious reason we don't know why the teller would have been deployed there, that we don't know what the instruction to the crew was, why the crew pressed the button, and how things could have gone so terribly wrong. What we do know is that it's not logical to position a standalone teller at that position near the front line. It's not logical to give an order to launch at that point in time, whereas MH17 was not the predetermined target. And according to the prosecution, in the vicinity of flight MH17, there was no similar aircraft that the DPR could consider to be an enemy aircraft or that would have been communicated by a spotter as such. By pushing the button at that point in time, whereas a civil aircraft was approaching, that could be recognized in all sorts of ways as such, that was flying on airway L980, an airway in which on 17 July 2014, in the morning alone, in a period of a couple of hours, in total 22 aircrafts flew by, and that nobody understands, and we know this, and nobody understands how nonetheless things went so terribly wrong, whereas the Taylor is equipped with a radar IFF system and a professionally trained crew. It is and remains inexplicable that things went so terribly wrong. And that doesn't give us the reassurance that the public prosecution is right. Particularly not if you keep in mind that actually all the evidence from which one could infer that the Buk missile would have been launched from the field near Pervomansky can be subject to several interpretations. Yes, it seems that perhaps there was a Buk tailor driving around in that area, but what does that really tell us? What does it say if you keep in mind that there were about 27 other Ukrainian tailors there? What does this driving around mean if it doesn't become apparent that the tailor actually proceeded to launch? And yes, black patches and track traces were found in a field near Pervomansky, but what does that tell us if you know that the entire area is full of patches and track traces, and that around that time they came about as well? And yes, a Buk missile casing was found, but that casing didn't appear to be the smoking gun that the JIT believed it was. The casing didn't even make it to the public prosecution's address. The prosecution doesn't give it any role in the evidence. And if you add to this that there's quite a bit of evidence that shows that things cannot have happened as the prosecution believes it happened, because there are several witnesses that have stated that no missile was launched from the area near Pervomansky, and also because the calculations point to a different location as a possible launching area, and the field near Pervomansky is even ruled out as a possibility, then you cannot simply resign yourself to the fact that things really didn't happen in a different way, that the truth doesn't boil down to a different scenario. We, in any case, cannot resign ourselves to that. The doubts about the correctness of the main scenario moved in the course of our work from a conviction to a conviction that the main scenario simply cannot be correct. But the question what actually did happen has not become less relevant.
We need to relate all our criticism about how little investigation was conducted into alternative scenarios to ourselves as well. We have not truly been able to investigate what happened either. The defense simply does not have those duties, means, and opportunities, and we were not offered those in this procedure. Virtually all requests to investigate alternative scenarios were denied by the court upon the application by the prosecution, and that the defense was not able to investigate alternative scenarios does not mean that we haven't kept asking ourselves what happened. We couldn't figure it out ourselves, and when the panel of U.S. Experts mentioned before, the team of experts that at our request peer-reviewed many reports from the case file, when that panel told us that they were encountering more and more questions and that they believed that the JIT scenario just didn't make sense, we therefore wanted to know what else they would say and what they would find. These experts took a different approach from the JIT. They started from the premise that the MH17 was hit by a missile launched from East Ukraine, and because the necessary data about missiles other than Buk missiles were not accessible or available, they restricted their investigation to the assumption, not saying that that's the case, but they restricted their investigation to the assumption that it was a Buk missile. The question they then addressed was not unlike what the JIT appears to have done, and not that it was a Russian Buk missile launched from Pervomansky, but the question was what could have happened. Who would have fired a Buk missile on 17 July at 4:20 p.m., and for what reason? The panel of U.S. experts that investigated what could have happened based on their experience, and as they did before for other aircraft crashes. That's how they approached the investigation. In conducting their investigation, they thought it was essential to consider whether all circumstances considered, whether in that case there was still an understandable and plausible scenario. And in their view, that requires considering not only the plane crash, but specifically why and how this could have happened. This topic was considered in the JIT investigation, but the answers have not been forthcoming, although in the words of these experts, circumstantial evidence and concurrent facts are present, but were not considered in answering these questions. Additionally, they mentioned that the Dutch Safety Board Annex 13 ICAO is said to have been deeply challenged by the war situation at the crash site. And they also mentioned the obligations pursuant to the ICAO Convention to have certain autopsy investigations conducted as completely as possible by pathologists experienced in accident investigation. These regulations serve to determine the exact position of all metal parts found and how those metal parts ended up there and in what direction. In addition, the U.S. experts extensively addressed previous accidents with civilian aircraft hit during wars or other conflicts. They emphasized that these previous accidents can yield valuable insights and the lessons learned for the JIT investigation, especially the investigation of TWA Flight 800, which crashed off the coast of New York on 17 July 1996, in the view of the experts, resembles the JIT investigation. Aside from an initial ICAO investigation by the U.S. counterpart of the Dutch Safety Board, which was the NTSB, the FBI conducted a criminal investigation and revealed fairly quickly that the perpetrators would be arrested. There was long speculation that a missile had hit this plane and caused it to explode. But after 4 years of intensive investigations, the cause turned out to have been flammable fuel fumes that had emerged in the kerosene tank. So no missile and no bomb. In the background of this investigation, the U.S. experts note that finding PETN as an explosive in the JIT investigation is insufficient because the booster of a book was not provided to the NFI. The importance of finding substances or other indications that may perhaps indicate a certain cause, such as PETN, but then failing to fully investigate those findings is clear from the TWA investigation. In that investigation, residues of explosives were found on 3 samples from 3 different wreckage items. In one sample, RDX was found, and in one sample, a combination of PETN and RDX. This discovery led to the idea that a bomb or missile had caused the explosion. The investigators in the TWA investigation did not make do with that observation. Only after in-depth investigation did the cause of these explosives become clear. It turned out to be a circumstance nobody had thought of. It turned out that 5 weeks before the accident, this aircraft had been used for an explosive detection test in which explosives residues had been placed on the aircraft. I do not mean to suggest by this example that such a cause applies in the present case, not at all. But this example clearly shows why, in events such as the present one, such an in-depth and extensive investigation needs to be conducted by experienced and expert investigators. And that is exactly what the U.S. experts note in assessing the JIT investigation. This is not a full and proper investigation to determine exactly what happened, how it happened, and why it happened. That would be the case only if the answers to these questions had been answered beyond dispute. The areas where the U.S. panels believed that the investigation was incomplete and which mistakes were made has been described in the 3 reports that I mentioned. We've referred to the first two in earlier days, and the third will follow. This also makes clear that our criticism of the JIT investigation and all the possibilities missed is justified to find the actual truth. Not only Pulatov, everybody has an interest in this, and this is exactly why we have requested that the prosecution account for choices in the investigation. Why was what decided in terms of investigation ideas and when? Only if the prosecution is transparent in that respect can the value of the JIT investigation be assessed back to the investigation by the U.S. experts. In this case, in addition to considering the JIT's findings in their investigation, they also considered public sources, flight data, geographic information, reports by locals, and so on. And then, based on the principle that the MH17 crashed as a consequence of an explosion from outside by possibly a book, but in any case a missile fired from East Ukraine, unimpeded by influences or restrictions of JIT partners or other countries, only then did they ask what would make sense. We asked these experts to depict their findings and to draft a report about it. We ask that your court incorporate the report, and will now show you the images. Basically, the U.S. experts consider it to be a plausible possibility that from the area of the launch area calculated by Almas-Ante, a Buk missile was fired at an unidentified aircraft that had approached just before from the Russian Federation. That aircraft was not recognized as the Air India civilian aircraft that it later turned out to be. Well, at that point, the threat of military aircraft from Russia was seriously considered. The tracking radar initially followed that Air India aircraft, but after the missile switched to the onboard radar, it searched for the closest and largest metal object to lock on that. And that the radar of that missile may have done a lock over onto that aircraft, which turned out to be the MH17 for several reasons. The alternative scenario, which initially may sound difficult to believe, is nonetheless plausible, especially with respect to the JIT scenario. I'll explain. In the JIT scenario, as stated, it not only remains unexplained, but is also inexplicable why the missile would have been launched and how such a mistake could have been made. At that moment, on that place, after all, there was nothing that could have served as a cause for a launch or a mistake, although everybody seems to agree that the MH17 could not have been the target. There was no other aircraft nearby that could possibly wrongly have been considered as a target, in any case, not according to the prosecution. Whereas in the Ukrainian missile scenario, that does explain why a trained crew, despite an eye system and checks of all characteristics, a launch was nonetheless decided. After all, there was a different aircraft coming from Russia, but not identifiable as a civilian aircraft at a moment that the Ukrainian armed forces were considering and afraid of military aircraft from Russia and were moreover losing ground. These circumstances might explain the decision to launch a missile. The circumstances mentioned by the U.S. experts, that could have been reason for the decision to launch, are supported by the record and public sources. Radar footage provided from the Russian Federation to Ukraine and in the record reveal identification problems, and that the Ukrainian armed forces were considering military aircraft from Russia, in addition to what appears in the report by the U.S. experts. This also appears in Primo 05427, according to which the JIT finds indications that Russian helicopters are conducting shooting, and separatists expect air support from Russian aircraft. The JIT then describes in the chapter Russian aircraft that there were indications based on which the JIT concluded that Russian air support appears to be expected. And then there were Ukrainian phone calls intercepted by the SPU. For example, there was one person who fought on the side of the DPR, who states on 13 July 2014, "We are waiting for aviation." Regarding the question as to whether this is friendly aviation, he answers yes. Aside from the conversations mentioned in that report, there were phone calls mentioning anticipated Russian air support. On 13 July 2014, Dubinsky is believed to have said, "In case these are ours and aircrafts are working." And on 16 July 2014, Koretz is warned about a friendly from the south that is not to be taken down. In other words, a non-hostile aircraft from Russia. On 17 July 2014, somebody else is said to have told Dubinsky, "We are waiting for Russia to fucking strike their positions from that side." Knowing that the SPO was listening to these phone calls, it's very realistic that the Ukrainian armed forces were considering the threat that the Russian Federation would deploy military aircraft. And it's also clear that they were considering that. For example, from the statement by a colonel who was in charge of the 299th Air Brigade of a Ukrainian army unit, he stated that Ukrainian aircraft had been taken down by Russian aircraft and or from Russian territory. And that suspicion is in part based on intercepts, which are intercepted phone calls. Aside from the question as to whether this is correct, it reveals that the Ukrainian combatants were considering a threat from Russia. That the Ukrainian combatants on 16 and 17 July faced a deteriorating situation is also clear from the case file. There we read that the DPR combatants were standing and gaining ground, and I've addressed this in connection with evidence question 2, but we're also discussing that in connection with evidence question 3. In the scenario described by the U.S. experts, there is also mention, unlike in the JIT scenario, of an explanation as to how things could have gone so wrong, how the MH17 could have been hit without being the target. This relates to the possibility called the lock-on, lock-over method. The case file reveals about this. Lock-on is crucial. The lock-on stage is crucial in the target search. At that point, the target has been selected and is being followed until the target is within firing range. If the radar unintentionally switches from one target to another, then that is a lock-over, end quote. Witness G9081 estimated this possibility as theoretical but in practice unlikely. G9081, according to the file, is addressing the possibility of a lock-on onto a Su-25 and a lock-over onto the MH17, but that's not what appears to have been the problem in this scenario. This concerns a lock-over from one aircraft to another comparable aircraft. RC-07 stated that discussing the possibility of accommodating a lock-over situation did indeed figure in his training and was addressed on a practice site. Not only is the lock-on, lock-over situation part of military training, and justifiably so, but unlike what G9081 appears to realize, it actually happens. For example, in connection with the Siberia Airlines aircraft discussed earlier, which was accidentally taken down by Ukrainian missile in 2001. The investigators of that crash concluded that there must have been a lock-over onto the aircraft taken down after the missile had missed its original target. And although the possibility of lock-on, lock-over is not common, it is certainly a possibility.
Now, the fact that the area from which the launch may have taken place was accessible to the Ukrainian armed forces is covered in the report. The investigators were able to ascertain that based on data from Live Universal Awareness Map. According to the investigators, that is a leading independent worldwide news and information site which focuses on factual reporting on various important topics such as conflicts, human rights matters, protests, terrorism, etc., and also based on information from a broad range of sources. And I've gone and had a look at this matter, and there was indeed quite some doubt about who others would have had access to that area aside from who the prosecution contends. Now, I'd like to draw a conclusion. The American experts considered the scenario set out and discussed to be plausible, or at least not highly unlikely. They conclude that the JIT investigation was insufficient and that the alternative scenario cannot be ruled out based on it. They say that based on the available data, it is possible that the Ukrainian armed forces fired a Buk missile to hit an aircraft which has not been identified, which was approaching from Russia at that point in time, and that missile had accidentally hit MH17 following a lock-on, lock-over. In so saying, they are not, and we are not, claiming that the alternative scenario is proven. But they are saying that it is a plausible, possible scenario. And not only because the JIT scenario, as I have said before, simply cannot be right, but also because this alternative scenario does seem to be right. In other words, because unlike the JIT scenario, the alternative scenario could make sense. Now, in Chapter 3 of these pleading notes, I have already explained that the Ukrainian missile scenario cannot be excluded based on the investigation results presented by the prosecution. I will now go into why we believe that there is actually support for the Ukrainian missile scenario, and that basis can be found in the case file and in other sources, and that therefore the Ukrainian scenario is plausible and certainly not incompatible with the admissible evidence. Let's start off with forensic evidence. The fact that and why another surface-to-air missile is not incompatible with and therefore cannot be ruled out by the legal evidence is covered in Part 3 of our pleading notes. Now, should the court find, despite our submissions, that a missile other than the Buk missile type is inconsistent with the evidence, in other words, then we say that the forensic evidence is in any case not inconsistent with the different launch area. Also, all the evidence given by the prosecution as evidence that it was a Buk missile can, in fact, at best indicate that it was a Buk missile, irrespective of its origin and irrespective of the launch site. And indeed, another launch area and or a Ukrainian Buk missile is not only not excluded. An alternative scenario, in fact, is better supported by the forensic evidence than the JIT scenario. And now I'm going to touch upon a point which has proven tricky for the prosecution up until now, and that is what type of Buk missile was it? Now, the prosecution has always beaten around the bush about this, and everything they have said has been a bit cryptic and contradictory. The prosecution has said that the investigation into the non-aircraft parts which were found have more in common with the 9M38M1, that is to say the new type of Buk missile, than the 9M38 old type. Given that the charging document is based on one missile, it cannot be both a new one and an old one. No, it has to be either a new one or an old one. And before it started presenting its case proper, we explicitly told the prosecution that it was essential that it make a choice and to specify which type of Buk missile had taken down MH17. However, the prosecution has not done so. Alma-Santai and the American experts have provided, with good reasons, that if it was a Buk missile, then it must have been an old one, old type one. Now, if it was a Buk missile, we have no reason to doubt what Alma-Santai and the American experts have said. But now the question is that if it was an old type Buk missile, well then, that fits better with the Ukrainian missile scenario than the JIT scenario for a number of reasons. First of all, the Ukrainian armed forces had old-type Buk missiles in operation. They were using them, and the Russian army was not. Furthermore, a missile casing of an old-type missile was found, the type that would have been in the possession of the Ukrainian armed forces. And finally, the lump that was found in one piece of MH17 wreckage can only have been found there in the case that a missile, following a trajectory after launch, that MH17 was hit by a missile on a trajectory from a launch location south of Zaroshensk. Now, I'd like to talk about the presence of a Buk tailor. As we have said, there are various pictures available of a Buk tailor in the vicinity of Snezhny. And based on that and intercepted telephone conversations, it appears that there was at most one possible teller with 4 Buk missiles present in that area under the control of the DPR forces. And the fact that a teller may have been present on DPR-held territory was not incompatible with the alternative scenario. Rather, the two can simply coexist. Furthermore, in eastern Ukraine, in that part of it which was under the control of the Ukrainian armed forces, there were 27 tellers present. That is to say, 27 launch installations which could have fired Buk missiles, and it is reckoned that there were at least 157 of such Buk missiles in the area. So the location of any tellers is not particularly probative, as they could be moved around. Now, in the case file, there are no video images or witness statements of Buk tailors in the vicinity to the south of Zaroshensk, but that doesn't mean anything. Unlike the area around Snezhny, parts of that area south of Zaroshensk are only very poorly populated, and for that reason, it is entirely possible that a Buk missile could have been launched from there without having been observed by witnesses. And there are indeed reasons to believe that there were TLRs present south of Zaroshensk at the point in time when the MH17 was downed. For instance, the satellite photos provided by the Russian authorities. Of course, the prosecution says that they were probably made on a different date, but there is information on the internet and other analyses of those satellite images which would indicate that that is not the case. Also, there are drone images. there are drone images showing that the Ukrainian armed forces were moving Tochka-Us around in that area. Now, Tochka-Us are generally protected by book tailors, and that means that Ukrainian book tailors were in the relevant area. Now, the fact that the Ukrainian armed forces had Tochka-Us in July 2014 is supported by various sources, and you can find references to them on the internet. And one of those sources is data from the United States intelligence services. And the fact that the DPR armed forces had drones which could make such images and did make such or take such images of Tochka-Us with book tailors in eastern Ukraine. Well, we know that because of the content of an interview given by a DPR soldier in 2015, which can be seen on the internet. And he describes drone operations and the results thereof. Now, in that particular interview, he doesn't refer to book tailors, but he does talk about Tochka-Us. And it is also clear from what the prosecution has said that the DPR were using drones. The prosecution has said open sources showed that the Ukrainian armed forces were shooting down drones during the course of the conflict. Now, the fact that it is possible that the Ukrainian armed forces had one or more tailors in the area is something that I covered under Chapter 3.7 when I talked about who had control of Zaroshensko. And from that, it is clear that that area south of Zaroshensko was also accessible to the Ukrainian armed forces. Indeed, the cartographer referred to in Chapter 3.7 explicitly said the following regarding this region. The location of the militia's air defense systems in this settlement seems impossible, and the armed forces of Ukraine are very likely, since they provide cover for the aviation of the armed forces of Ukraine, which was actively operating in the area of Zugresh, Shakhtarsk, Snizhnoye in the period 10 to 17th of July. So that cartographer felt that not only was it possible, but indeed that it was probable that Ukrainian air defense systems were present in the area to provide protection against possible assaults on the Ukrainian Air Force. Now, I'd like to talk about evidence of a launch. As said, there is a lack of conclusive evidence of a launch from the JIT field near Pervomaisky. Indeed, the images and telephone conversations available tell us nothing about whether a missile, let alone the missile that downed MH17, was launched by a telar that was possibly in the DPR. No launch can be seen on the images, and there is nothing about a launch or order to launch to be heard in the conversations. Despite 7.5 years of investigation, other than some tracks and traces in the vicinity of the field, for example, a black patch, track marks, a vapor and smoke trail, all of which may easily have been caused by other things, there are no reliable usable witness statements. There is no forensic evidence of a launch at that location. There are no satellite, radio or drone images, no radar tracking records, and no talk of a launch in the intercepted telephone conversations available. In fact, the only witness who provides extensive statements regarding a launch he witnessed is witness M58, and parts of what he says does not match with the JIT scenario. M58 not only provided highly unreliable and inconsistent testimony, but also seems to be mistaken and to be relaying his recollections of a launch other than that of the missile that downed MH17. He also seems to have been influenced by JIT press conferences, and he only points at the JIT field when those who are questioning him tell him that the launch must have taken place in the vicinity of Pervomaisky. And he only does so after he has already pointed out a different location. Now, the other witnesses, insofar as their statements can be used, talk about launches at other locations and or about the fact that they say it was not possible that there was a launch from the JIT field. Furthermore, the tracks and traces around the JIT field and advice of that type does not contradict the alternative scenario. Now, whether there is evidence for a launch from a location south of Zaroshenski is not known. Indeed, we do not know if there are witnesses who could testify to that, but that's not surprising given how likely the area is populated. It is not known whether there is forensic or supporting evidence for a launch from a location south of Zaroshenski, except for the bit of research or investigation was done into one field. It is not known if there is satellite, radar or drone images or radar tracking recordings of a launch near Zaroshenski. No evidence was done, and there's no expectation that the Ukrainian authorities would have volunteered such information. And last but not least, it is not known whether the Ukrainian armed forces spoke in telephone conversations about the events of the 17th of July 2014. All that has been provided in this case are intercepted telephone conversations by DPR fighters. We cannot know what the Ukrainian armed forces may have said regarding a possible launch or an order to launch. Basically, the admissible evidence are not incompatible with the alternative scenario, in fact, are quite open to that possibility. Now, although there is no onus on the defence to prove an alternative scenario, and of course the defence is not claiming at all that it has done so, what there is are indications that support an alternative scenario, particularly with respect to the JIT scenario. The lack of reliable evidence for a launch from the JIT field raises questions regarding the plausibility of the JIT scenario, particularly given the fact that an intensive 7.5-year-long investigation into that scenario has taken place. Now, the JIT investigation did not focus on the alternative scenario. Few evidence has been provided regarding it, and also the area concerned south of Zaroshensko was only very lightly populated, and so it would be entirely plausible that a launch would have gone unnoticed. So, compared to supporting evidence for the JIT field, which is open to interpretation and is not specific, for example, tracks and a smoke plume, the cause and precise point in time and location of which is not known. So compared to that, what we have is very little investigation into the vicinities of Zaroshensko, with the exception of one field. And compared to unreliable, uncredible, and unreliable, unbelievable or uncredible influence witness who says that he saw a launch by Pervomaisky, what we have is credible, much more credible, and numerous witnesses that there was no launch of a Buk missile in the vicinity of Pervomaisky. And compared to the single non-operational Taylor that was possibly present in the DPR-held area, there were 27 Taylors in the surrounding area being operated by Ukrainian armed forces. And compared to Buk missiles, compared to there being 4 Buk missiles in the DPR-held area, there were at least 157 Buk missiles which were combat-ready in the Ukrainian-controlled area. And compared to the calculations which were carried out by one Dutchman and one Belgian, who had no relevant experience with Buk missiles and in investigating aircraft accidents, and who came to the conclusion that the missile had been launched near Pervomaisky, what we have are calculations carried out by a Russian institution and the assessment of an American institution, in each of which are far more experienced and expert, and who have concluded that the missile cannot have been launched from near Pervomaisky, but rather only from south of Zaroshensko. Finally, the questions unresolved by the JIT scenario are answered by the alternative scenario. rather than a lack of explanation why the missile was launched and how it went so wrong, we have an explanation as to why a missile was fired and of how it went so wrong in the end. All things considered, the alternative scenario whereby a missile or a Buk missile was fired by the Ukrainian armed forces from the area south of Zaroshenske and MH17 was unintentionally downed is not inconsistent with the evidence, insofar as that evidence is reasonably reliable, and is indeed plausible, perhaps more plausible than the JIT scenario. I'm arriving at the end of my submissions on this topic now. If another scenario that is not highly unlikely and is not incompatible, if another scenario that is not highly unlikely and is incompatible with the charges cannot be ruled out, then the accused should be acquitted. The alternative scenario that I have set out is not highly unlikely, but in fact plausible. What is more, it is not ruled out by the evidence presented. For this reason, it cannot be concluded that the charges are proven and a full acquittal should be given. Very good. Thank you very much. We shall now break for lunch and we shall resume at 1:15.
will rise. Please be seated. Court is in session. Yes, you have to hand over your pleading notes. We're just picking up a couple of copies that we have for counsel of the relative. Let's just wait a moment because I think you need a table of contents as well. I think that we have everything. I have handed over my pleading notes, the annexes, and the table of contents. And I believe that the annex of the pleading notes that we've just finished copying has just been handed over. So, I think that has been done. And members of the bench, members of the prosecution, counsel for the relatives, ladies and gentlemen, I will be discussing what we now call evidence question 3. And this afternoon and also on Monday, I'll continue with that. I will be talking about the factual behavior, and once that has been wrapped up, Ms. Tenduschater will close this part on Monday with the legal aspects of participation in this case. And then we will have addressed all 3 questions. President of the Court, you'll have to wait to see when you want to have a break. I'll leave it to you. Right, and I will start with paragraph 1 for the clerk. In this section of our oral pleadings, we shall be discussing the question whether our client can be proven to have participated in some measure in such a way that he is culpable of participating in the scenario as charged. It is evident to the parties in the proceedings that if this scenario cannot be proven or can only be partially proven, your court will not get around to this question. We will only deal with this question in the case that we do not expect, in the case that your court were to follow the public prosecution with respect to the two most important sections being identification of the missile and launch location. In the prosecution's address, the prosecution already made an attempt to explain and interpret the role of our client in a factual and legal sense on the basis of what little material is available. We criticize both the factual part and the legal part, highlighting that the participation experiment led by the prosecution in this case has failed. I shall start with the factual part and I'll run through the sources of evidence mentioned in the prosecution's address. After that, as I said, Ms. ten Dusschater will shed some light on the legal aspects. I shall discuss the acts, the factual acts mentioned in the public prosecution's address. What we will not discuss are two topics that were mentioned in the public prosecution's address, but that do not have a direct link with the indictment. This is the so-called context and the what the prosecution called, and I'm quoting, war violations by the DPR. In terms of the description of the context, it strikes us that the prosecution's address does not provide a balanced description of the events in April 2014. When the court presented the documents, this balance with respect to this topic was put forward. Reason why we do not consider it necessary to discuss the particulars of this subject matter. At the same time, the prosecution uses these two topics in order to support the image they wish to portray of the DPR, namely a category of common criminal organization that, according to the prosecution, was mainly focused on downing aircraft. Reality is obviously quite different. When war violations were mentioned, the prosecution referred to factual results of investigation. But, Your Honours, the present case is not focused on that, not if we look at the charges. We cannot and shall not put forward a defense in this respect because it lacks interest. Before starting my substantive factual points with respect to participation, I would like to draw your attention to everything we do not know. What we do not know with respect to the gist of the events, the center of the events that we believe took place from 2:10 p.m. to 4:30 p.m. on 17 July 2014. With respect to this question, the prosecution on 9 June 2020 put forward the following. All in all, the case file provides no decisive answer with respect to the exact course of events during the downing of the aircraft and the launching of the missile. In June 2020, the prosecution added that the charges do not specify that the defendants themselves pushed the button, indicated a target, or ordered the crew of the tailor to fire. They're not being prosecuted as factual persons who actually performed the firing process. And the prosecution said the investigation has not been able to provide any decisive information on the specific reason why the aircraft were shot down. So we don't know exactly, according to the prosecution, what the crew did and how it set to work. And so the specific reason for firing need not be established, according to the prosecution, for the evidence. And the prosecution also, I'm skipping one or two quotes, this is paragraph 10. The public prosecution's address, the prosecution says the following. We do not know exactly which instructions Gherkin gave in the morning of 17 July 2014. We do not know exactly how the crew of the tailor communicated with the 4 defendants, nor do we know what the reason was to fire the missile. And due to these problems in terms of evidence, the prosecution started to look for a form of participation that would have to lead to the fact that a person of whom, if we simply go along with the material put forward by the prosecution with respect to our client, a person of whom essentially we can only determine that he may have become familiar with the presence of an anti-aircraft system, and that only by knowing and being familiar with that you can be held responsible for the launch of this system and the implications thereof. And this without knowing why the system went off and who ordered the system to be launched, and without knowing, and that on the basis of only telephone conversations carried out in a war environment. And, Your Honours, this cannot be the idea of our criminal law system, not even when facing events with these terrible implications. There is no criminal culpability. And knowing about the presence of the system, that simple fact cannot be proven. And I just decided to put my public prosecutor's cap on. Based on the public prosecution's address, I shall now speak about the position of our client, hierarchically speaking, his duties in general, and specifically on 17 July, the meaning of the information derived from the conversations that there was a need for anti-war defense systems, anti-aircraft defense system, contradicting facts and circumstances, exculpatory circumstances that have not been qualified as such, and finally, the remarkable qualifications on the part of the prosecution, such as a group of perpetrators that work closely together, ownership and power of control. The value of telecom evidence and geolocation will be addressed, as well as the command structure that is connected to the deployment of a book tailor. It was discussed just now. Telecom data. When we presented the preface to our oral arguments, I emphasized that the prosecution, in earlier explanations, stated that we have to cautiously deal with telecommunication mast evidence, but that this cautious attitude is not reflected in the rest, because the word transmission mast appears 27 times, the word transmission mast 18 times, and transmission mast data 13 times, along with graphical images by way of indication of locations where the callers were located. And before I discuss the different intercepts of conversations, I'd like to point out that the defense commissioned a very experienced international expert in the field of telecom data to assess the metadata in this case, and also to look at, and this is a more technical interpretation of the data. The report has been attached to these pleading notes. The report is called Cell Site Evidence. We can infer from this report that this expert, a British expert, has acted in more than 500 cases as an expert, both for prosecution and for defense. And these were cases before the Lebanon Tribunal, the International Criminal Court in The Hague, the residual mechanism of Yugoslavia, and the Rwanda Tribunal. Very experienced. His main conclusions after studying the documents are the following. The analysis of metadata can help to identify the person who ordinarily uses a specific telephone, but cannot determine who used the telephone at a time at which a specific connection was made. The analysis of metadata can be used in order to try to retrace in which area a specific telephone or the user of a telephone could have been at the time at which certain connections were made. where in this area the user of the telephone was when the connection was made cannot be determined based on the analysis of metadata. In rural areas, the coverage of one single cell can cover hundreds of square kilometers with a maximum range of even more than 1,000 square kilometers. Even though the name of a cell location could be convenient for an easy reference, according to this international expert, it's too vague to mark the specific location of the cell. And so he says it is common that the location of the cell is registered as a grid reference or by means of latitude and longitude coordinates. In present case, the transcripts only contain the address of a cell location, and in some cases a street name and a town were mentioned, but in other cases only the name of a building or a village was given. He says it has not appeared to be possible to, by means of open sources, and he tried to do this, to determine the cell locations with the required degree of certainty. Even if a street name is mentioned and a town is mentioned, it is not possible to identify a specific location in that street. And in many cases, it was only possible to determine the town that serves the cell location, possibly serves the cell location. And due to this limited degree of accuracy in determining cell locations, he says, it unfortunately has not appeared to be possible to determine the exact coverage area of specific cells with sufficient certainty. And as a consequence, the analysis of the metadata in this case can do no more than determine the general area from which a certain telephone connection was made. Since there is no accurate information on the cell locations, furthermore, he says, we have to depart from a relatively large potential coverage area of the cells. The telecom expert produced a map, which is added to the report, and that map shows the size of the area that could be covered by a cell location. Due to the uncertainty about many of the cell locations, in the case at hand, we cannot per se assume, he says, that the user of a specific mobile telephone was even in a specific town as referred to in the cell location. Annex 2 of one of the primos specified in the pleading notes, we can infer that network measurements were carried out in 4 specific locations in the area around Snitsnoy and the roads around several towns. He says this study cannot contribute to determining specific cell locations. The study can only show that specific cells gave coverage in a specific area, as expected. The metadata of a specific telephone conversation only specify the cell or the cells that at the beginning, he says, and possibly at the end, that were used at the beginning and possibly at the end of a conversation. It doesn't indicate which cells were used during the conversation, and the telephone could have been moved immediately after the beginning of the conversation. The fact that a mobile phone during a specific period of time uses a specific cell, says the expert, does not mean that the telephone would be located at one specific location. The telephone could have moved within the range of the cell. By means of co-location, it can be established that 2 telephones around the same point in time were located in the same area. But, he says, it cannot prove that the telephones were actually at the same location near each other. The analysis of metadata is often used in order to support a specific position. So he says alternative scenarios that could just as well fit the data, he says, given his experience, should always be considered.
Specifically regarding the data of the phone numbers now attributed to client by the prosecution, the expert reached the following conclusions. On 16 and 17 July, the mobile phones ending in 2511 and 2177 both used different cell locations in the large area of Turezhnishne and Perfomaisky, and later on Donetsk as well. The entire coverage of the cells used cannot be determined with any degree of certainty. Assuming a cell range of 8 kilometers, the area within which the user or users of these phones could have been at that point could, he says, also comprise 9 surrounding villages. Since the maximum coverage area of a cell is 35 kilometers, this area can therefore be still larger and comprise still more cities, he explains. The prosecution has asserted that the 2 phones attributed to Pulatov were consistently in the same surroundings on 17 July 2014. The expert says that the word surroundings can be misleading. In this case, the 2 mobile phones were in the same general area, but that does not mean that they were necessarily in the same neighborhood or surroundings or had been there. Using the word surroundings suggests that they were located on the same street or at least in the same section of a city, but cell location analyses cannot result in such a specific identification of place and location. Given the coverage of individual cells, the 2 mobile phones could be 20 kilometers away from each other, which does not match most people's definition of in the neighborhood or in the surroundings of. The prosecution has asserted that on 17 July, Pulatov tried to contact the bookteller crew. The available data reveal only, 1, that no connection was established between phone numbers 511 and 335, to mention the last 3 digits. 2, that 335 did not try to contact 511, and 3, that the user of phone number 335 was in the general area of Shnishnoy on 17 July at around 2 p.m. The extreme lack of information regarding the 335 phone number, the phone number ending in 335, entirely precludes determining or refuting that the user of this number was a bookteller crew member, according to the expert. That was what I had to share about the report. Our additional conclusions based on this report, considering the Primo file, are as follows. The cell site information listed in the transcript include names, but these could be names of what were known as host premises or the name of a village, city area that it serves. See what I mentioned about this earlier. That's how the report reads. That's a convenient reference point, but at the same time is too vague to pinpoint the exact location of the cell site. Nor did the expert succeed in doing so via public sources. This means that none of the transmission mast locations in the file can identify reliably when a connection between 2 phone numbers was established, where the user of the intercepted number was located. The transmission mast identifies only a general area within which a connection is established between a phone and a transmission mast. For lack of of accurate cell site location information, the coverage of that transmission mast should be considered larger than indicated. This renders uncertain whether user was actually in the village or area indicated according to the cell site information. The rule of thumb indicated by the expert is then that the maximum distance between a transmission mast and a phone is 35 kilometers. In populated areas, this can diminish to 1 or 2 kilometers. It can be as little as 1 or 2 kilometers, but along the edges of built-up areas, it can be 5 to 10 kilometers or even 15 kilometers or more in an open field. Another one of our conclusions is that moving a phone during a conversation, cannot be traced, so not via the transmission mast. The fact that two phones communicated with the same transmission mast during a conversation does not prove that these phones were in close proximity to each other. Considering the prosecution's address in anticipating subsequent specific evidence defenses, at this point I would like to note 2 remarks from the prosecution's address. The first is the remark that the 335 number at 1:52 p.m. on 17 July communicated with the same transmission mast as the one Pulatov was using. The value of this observation, which obviously suggests something, is in the view of the telecom expert nil. Second, the prosecution mentions the 2 numbers attributed to Pulatov and asserts that these phones communicated with the same transmission mast and were therefore in the area of each other. This conclusion cannot automatically be reached, and the question then arises as to what's the radius of in each other's area, in each other's surroundings. Those were some general remarks about the telecommunications and transmission mast evidence based on the expert that we commissioned. Now, on to a different topic, which I've called the hierarchy within the DPR. The prosecution's address contains various remarks about the hierarchy within the DPR. In several sections, the prosecution asserts that Girkin and Dubinsky were at the top and that Kharchenko and client were their immediate subordinates. At the same time, the prosecution insinuates that Kharchenko sometimes received orders from our client. This is based in part on a conversation in which our client did not take part and where Jurza mentioned, who has not been positively identified as Pulatov. Other questions on which this assertion is based are conversations relating to counting the injured and telling another DPR soldier that Kharchenko's troops have arrived first. Careful reading of the translations of these conversations do not indicate giving orders, but information exchange and consultation and coordination between 2 soldiers at the same level, but logically need to coordinate their troops and displacements. That's exactly what Pulatov stated, which was that he ensured that other commanders were aware, for example, of the presence of tanks available to the DPR so that they could then coordinate deployment of these tanks. This was not limited to a single unit, but concerned virtually all units along the front line with which he had to communicate, according to him, because he was responsible for their coordination. One of these units was that of Kharchenko, and especially the contacts with that unit figure in this case file because Kharchenko is considered to be a defendant, but that doesn't complete the picture. All the other communication duties of Pulatov with all the other units hardly appear in the case file. And that, Your Honor, could be because the phone numbers attributed to client were not actively intercepted prior to and on 17 July 2014. This happened only from 21 July 2014 onward. The only conversations and transcripts attributed to client before that, and in the case file, conversations he was believed to have conducted with persons who were intercepted, so he was the B party. Conversations with other non-intercepted persons are not available, while specifically those could provide a lot of context and further substantiate the point of the defense. In addition to that word, many, that we repeatedly heard in the prosecution's address, we also heard about alleged reporting. Two other conversations that the prosecution mentions in the address concerning communicating the number of injured and discussing the Strela 10 that was hit are wrongly qualified as Karchenko reporting to Pulatov, apparently to indicate that there was an authority relationship, that Pulatov regularly requested all units for information, and consequently to that, that of Karchenko as well, aligned with his intelligence duties. He explains that he had to help the commander position on location, learning the situation around us, so that he could set up the interaction with the units that he would be supporting. To perform this duty properly, he depends on information and requesting this information, as may be heard in several conversations, which is not a subordinate reporting to a higher-ranking commander. In the Primo case file, the JIT mentions a few more conversations based on which Pulatov appears to be instructing Karchenko and Karchenko reporting to Pulatov, but also with those conversations, correct reading of the translations does not enable such a conclusion. They more likely suggest the contrary. One of these conversations reveals, for example, that Pulatov says that Karchenko should have warned him that he was going to Donetsk, and then Karchenko says that Khmury instructed him to come there. Next, it is clear from the conversation that Karchenko and Pulatov are talking about the fact that they received different orders and do not understand why that happened. The translated word orders is used in the conversation, but not as an order from Pulatov to Karchenko. No, this concerns different orders from Khmury to these two, based on which Pulatov tells Khmury that he will report to Khmury. In addition, I would specifically like to mention conversations based on which it may be inferred that Pulatov and Karchenko are equals. One example is the conversation not incorporated to date that took place on 15 July at 10:52 a.m., and I've copy-pasted that conversation in my pleading notes, but will not read it out entirely, and it makes abundantly clear that they are peers rather than a subordinate and a commander. And there are many other examples of such conversations in the case file. In addition, Pulatov stated that Karchenko's unit came under his command only in late August or early September 2014, not earlier, and this view aligns with what the JIT revealed at the press conference on 19 June 2019, and I'm going to play that footage from the video for you again. Pulatov was deputy in the intelligence desk and one of the deputies of Dubinska. defendant Kharchenko was directed by Dubinsky and was in charge of a military unit in the region. Well, that's perfectly clear. The JIT states and shows the entire world that Dubinsky was the one who instructed Kharchenko, not Pulatov. So my partial conclusion relating to hierarchy is that the suggestion of the prosecution in its address that Kharchenko was a subordinate of Pulatov in July 2014 lacks foundation and is incorrect. Regarding the hierarchy in the DPR, the prosecution asserted in its address that that hierarchical structure is relevant but is not decisive. Regarding the factual description of Pulatov's actions in the charges, which was that he used his authority to guard and conceal the book teller, this observation is decisive. Based on conversations I'll describe later on, it may be inferred that persons described by the prosecution as guards were in contact only with Kharchenko and not with Pulatov, so it cannot be proven that Pulatov guarded and or concealed a book teller. Now, Pulatov's duties. In addition to the intelligence duty of Pulatov I just discussed, the prosecution makes it appear as if Pulatov was also involved in a specific remit within the DPR, i.e. Air defense. Two call signs were mentioned by the prosecution, i.e. Kep and Korets, and the name Tsemak. The number ending in 511 was not in contact with two of these three persons about an anti-aircraft. The two out of the three are Kep and Tsemak. This already indicates that this specific section was not part of Pulatov's duties, and he never mentioned this as one of his duties. The conclusion is that Pulatov's remit concerned intelligence and not anti-aircraft, so he figured within a cohesively working group of perpetrators, according to the prosecution, focused on taking down aircraft. Now, regarding the task area of Korets and air defense, one of the conversations mentioned in the prosecution's address to relate Pulatov to anti-aircraft is the conversation between 511 and the phone attributed to Korets on 17 July at 7:01 in the evening. Regarding this conversation, however, Pulatov stated that he does not know who participated in this conversation and that he does not know who was behind that call sign. That's striking because Pulatov, unlike other taps presented to him during his video interview, did not respond by stating that he did not recognize the voices. At the same time, it's also credible in light of the fact that, given the additional speech comparison by the NFI, another conversation used between 511 and the call sign Korets scores lowest in the speech comparison. I'm referring to a comparative speech comparison that surfaced in the NFI's file later on, and that it scores lowest appears in Table 4 of that report. And this conversation has the lowest score. 3 conversations compared with this conversation have a roughly 50-50 score of being the same voice, and with another 4 conversations compared, it is only somewhat more likely that the speaker is the same or than a different speaker. And by somewhat more likely, the NFI means that the likelihood is of this comparison is only 1 to 5 times greater if one hypothesis is true than if the other hypothesis is true. So that's a low assessment. And in the investigation of what's known as the native language speakers, which is distinctive from the computer-generated analysis, this conversation raises doubts as well. Finally, the third method, known as the blind analysis, yields the same doubts. In this method, the NFI investigator decides that of the 19 conversations presented, including 2 distractors, the investigator divides them into 4 groups, including the group comprising choreits, and qualifies the measure of conviction between the group that choreits appeared and the subsequent group is qualified as weak, and the measure of conviction that speakers in all groups are not the same is qualified by the investigator as normal. And Pulatov's voice, to put it that way, in the reference calls and the choreits call were used in different groups, and this analysis reveals that they qualify as normal. The conversation of 17 July at 7 p.m., in which Pulatov does not recognize the voices, also surfaces in the NFI report I mentioned. The scores for this conversation vary, and this conversation has been identified as B10 in that report. In the automatic comparison, once a score of -1 was attributed, indicating that it's somewhat more likely that the speakers are different rather than the same. And it is qualified as twice as likely that they are the same rather than different speakers, and 1 times more likely and 5 times far more likely. In one of the native language speakers, the conversation has not been included in the group of the same speakers, and in the blind analysis, the conversation figures in a group of only 3 other conversations of the 14, in which the measure of conviction that the speakers in the 4 groups are not the same is, just as I just indicated, qualifies as normal.
So, what do we conclude from this? Well, given that Pulatov was not identified in the speech comparison study, there is no convincing evidence that Pulatov was the one speaking with choreits in the conversations in question. Now, these conversations are those on the 16th of July at 3:28 p.m. and the 17th of July at 7:01 p.m. It should therefore be noted that Pulatov's statement is credible when it comes to the conversation in which he himself has strong doubts that he took part. In this connection, it should be noted that Pulatov has said that at any point in time he had 8 different telephone numbers available to him, and that he had various mobile phones, and that sometimes those telephones and numbers were exchanged with other militia members. He added, moreover, that he regularly used number 511. Regularly, so not always. And that is not in contradiction to his comment that he could always be found on that number. What he meant by that was that he could always be tracked down via that number. For instance, somebody accompanying him in the car, for instance, who had that phone, would be able to say where he was. And that does not mean that various others could not have been using the phone. In fact, he stated that that was sometimes the case, that someone else used the phone. I would also recall that in his video statement of the 22nd of October 2020, Pulatov said, "I recognized some of the voices and I didn't recognize others." Now that is why, when asked earlier in this trial whether our client admitted that he took part in the conversations I've referred to, we chose our words carefully. Now, the prosecution referred to a number of other conversations between Koreits and number 511. Despite what the prosecution claims, it cannot be inferred from those conversations that Pulatov had under his control an air defense unit of which Koreits was the commander. Although that is something that was asserted by the prosecution when it presented its case. Now, the relevant conversations must be seen as Pulatov gathering information and intelligence as part of his coordinating role, as described earlier. When asked about the nature of his activities, he explained the following in his statement. If I'm to put it in general terms, I would say that the key tasks focused on gathering intelligence and data, planning, preparation of special operations and executing them, as well as interacting and coordinating with other armed forces. Later, when presenting its case, the prosecution seemed to suggest that Koreits was involved in the offensive on the 16th of July 2014, in which 2 Su-25 airplanes were downed. It is clear that in so doing, the prosecution is trying to link this with its contention that Pulatov was part of a group of perpetrators coordinating closely to down airplanes, in this instance via Koreits. However, there is no evidence that Koreits downed the airplanes referred to, nor did the JIT investigation focus on that particularly. In fact, there is relevant information indicating that another unit downed those airplanes. Now, late in 2021, the defense requested information from the prosecution regarding the so-called Wagner operation. In reply, by letter dated 27th of November 2021, the prosecution provided it with items for its inspection, including translations of conversations with Kharitonov. And I have appended those documents to my pleading notes today. Now, it can be inferred from those translations that his unit, under the command of Samurai, downed the airplanes on the 16th of July 2014. Furthermore, it can specifically be inferred from a list of nominees for an award for downing those 2 airplanes that Section Commander Yurevich, assisted by 2 named crew members, fired the missiles. There is no evidence whatsoever that Pulatov was in contact with that unit or those persons, nor that they were under his command. The fact of the matter is that there is nothing relating or linking Pulatov to those events on the 16th of July. And as I said, the documents provided to us for inspection are appended to my pleading notes. We request that these be added to the case file. Should I take a break? No? Okay. I'd now like to move on to the list of airplanes downed. When presenting its case under its section on tasks relating to air defense, the prosecutor looked at other airplanes hit over the course of the conflict from the 22nd of April to the 16th of July 2014. When doing so, they referred to the LPR rather than the DPR. Once again, there is no evidence whatsoever that Pulatov was involved in any of those incidents or that they took place under his command. Neither were these incidents specifically investigated by the JIT. For instance, no witnesses were selected or questioned about them on the Ukrainian or on the separatist side. And if the prosecution is asserting that the 4 accused constituted an organized group largely focused on downing airplanes, and is asserting that based on the incidents on that list, we would point out that there is no evidence at all of Pulatov's involvement in them. Your Honor, I'm just looking to see whether I should take a break. I'm about halfway through what I wanted to present. It's up to you, Counsel. Well, actually, I'd quite like a short break, if you don't mind, just to relax my voice for a moment. Very good, says the judge. Yes, we must also remember our interpreters. So let's take a break now until 2:30. Thank you. All rise. Please be seated. So the hearing is now resumed. Mr. Van Eyck, you have the floor. Thank you, Your Honour. I was at chapter or section 1.8 in my pleading notes, advance reconnaissance and coordination of troop movements. Two other tasks were cited by the prosecution with respect to Pulatov. These were advance reconnaissance and coordination of troop movements. These tasks were referred to in the chapter entitled Request for the Book Teller, thereby intimating that these tasks related to the requesting of such a weapon system. But that is pure fantasy, and I will explain why. The prosecution stated that in southern Donetsk, from the 6th of July 2014 onwards, the DPR was trying to force through to the Russian border, and that Pulatov was engaged in advance reconnaissance south of Snizhny, and that in the direction of the border, and was reporting on it to Gherkin and Dubinsky. Now, the prosecution did not provide anything harder than that. When presenting its case, it did not explain what this advance reconnaissance consisted of. For this reason, we recently consulted our client on the matter. The video recording of that consultation, translated into Dutch by sworn interpreters, will not be shown now, but will be provided to the parties to these proceedings, and we will provide a USB key to the court itself and to the prosecution with that video recording on it. Now, as you will see when you read the subtitles on the video, the tenor of what he says is that this advanced reconnaissance work had nothing whatsoever to do with positioning an anti-aircraft weapon, nothing to do with the Buk Teller, and nothing to do with the area south of Snizhny. He explains that advance reconnaissance south of Pervomaisky, if that is what is being suggested, would have been pointless given that that area was already under the control of the separatists. Now, in the same paragraph of his speaking notes, the prosecutor asserted that on the 15th of July 2014, Pulatov was appointed as, and I quote, coordinator of all DPR troop movements in the area. Now, that is quite a different type of coordination in comparison to what Pulatov said he was involved in coordinating. Pulatov said that that coordination was coordinating the behavior, the conduct of troops, but the prosecution is talking about coordinating troop movements in the area. It is not stated in that paragraph of the prosecutor's pleading notes what that assertion is based on. However, from another page in his pleading notes, we infer that the prosecution is basing this on a telephone conversation that took place on the 15th of July 2014 at 14 seconds after 10:54 p.m. And I have included the English translation of that whole short conversation in the pleading notes. And I'll read that to you now. It starts like this. Hello. Answer. Commander, do you have Gürza's telephone number? B. Gürza's? A. Yes. B. No, I don't. Do you need to find Gürza's telephone number? A. No. I have it. It's just that this one is like a coordinator of all forces that have been dragged and are being dragged there. B. You come to Snizhny and we'll get everything planned here. A. B. Come here quickly. A. Okay. B. Bye. Now, in that conversation, someone asks the call sign Kim whether he has a certain Gürza's telephone name. Kim says that he doesn't have that number. The other person then says that, oh, he does have it after all. Then the person he's talking to says, he says, yes, I do have the number after all. And then he says, and I quote, it's just that this one is like a coordinator of all forces that have been dragged here and are being dragged here. So basically, one of the speakers in this conversation says that this Jirza is like a coordinator of all forces. So that person is speculating, and as we all know, speculation is of no value in a criminal trial. What is more, there is no information on the context in which this conversation took place. It is also unknown what Jirza is being referred to in the conversation. Now, surely the prosecution is not making such an important assertion without additional reasons, and that based only on a vague sentence, which it in fact has misinterpreted. Is the prosecution on that basis asserting that Pulatov had been appointed to coordinate all DPR troop movements and the movement of Abu Taylor? Your Honour, it is ridiculous that we are expected to give a serious rebuttal to that. So on this point, I would conclude on the matter of advanced reconnaissance and coordination of troop movements. These aspects evoked by the prosecution when presenting its case are, on the whole, not linked to the presumed deployment of Abu Taylor. So now I'll move on to something which is probably a more important point, and that is the motive of a growing need. Growing need being the term used in the prosecution's presentation. So starting from these various positions, looking for a possible motive for its own scenario and case, the prosecution pushes on with the assertion that around the 16th and 17th of July 2014, there was a growing need for powerful air defense. Now, the evidence for this, once again, only emanates from intercepted telephone conversations, given that no witnesses have been questioned on the matter. And as we've often said in presenting our case, these are all conversations that took place while the speakers knew that they were being listened in on. And none of the speakers has wanted to or been able to comment on these conversations aside from Pulatov. Now, it is common knowledge that in times of war, such conversations are used to mislead the enemy. But interpreting these conversations as if there was no war and as if every word spoken can be taken as being 100% true is very risky indeed. Furthermore, it isn't logical to consider that around the 16th or 17th of July 2014, there was a need for anti-aircraft weaponry that could strike large airplanes. And let me explain why. First of all, the overviews presented by the prosecution itself show that the DPR was well able to defend itself from airstrikes with the equipment available to it. And this is apparent from the Frontlines official report that I will now address. Both when presenting its case and when presenting the conclusions of the official report entitled Frontlines, the prosecution has given the impression that around the 15th to the 17th of July 2014, the separatists were losing due to the Ukrainian Air Forces the Ukrainian Armed Forces offensive, and that they barely had a military response to the Air Force's airstrikes. But that conclusion isn't in line with the facts set out in the official report. On the contrary, it is apparent from the report that the separatists were holding up well and were in fact winning ground. I'll give you some examples of this from the Frontlines report. These examples also include the run-up to the 15th to 17th of July, as well as the 15th to 17th July 2014 themselves. So first of all, on the 7th of July, the Ukrainian army made an attack on separatist positions on Sour Mogila in an attempt to take the hill. There was heavy fighting as a result of the attack, in which the Ukrainian army suffered a large defeat. Despite that defeat, much fighting reportedly continued in the following days. Then, on the 12th of July, fighting ultimately began around the Izvarino border crossing. The Ukrainian Air Force was deployed during this fighting too, and 2 Su-25s were reportedly also downed during the fighting. I'm quoting the Frontlines report.
On 13 July, TASS says that around Samogilia, about 300 Ukrainian troops would have relinquished to the separatists. In the night of 14 to 15 July, the separatists carried out an attack on the checkpoint near Stepanovka. Tuesday, 15 July, the city of Stepanovka was taken by separatists. They would have dug trenches, and Stepanovka would have become a new outpost. That same day, the neighborhood of Snitsne was controlled by separatists and was shelled from the air. And the Ukrainians denied to have carried out this attack because they say they did not fly on the 15th, as we read in the official record. On 15 July, the separatists say that the Ukrainian armed forces that evening hurriedly left their positions at Krasnodon. They would have withdrawn about 30 to 40 kilometers from Izvarino. One day later, however, there was still news that the border post was still, Izvarino was still being shelled by separatists, and that the Ukrainians were surrounded. And the following days, there was still a lot of fighting. On 16 July, Samogilia was bombed by the Ukrainian Air Force. A Ukrainian attack was carried out in an attempt to reconquer the hill. The entire month of July, the hill would be in the hands of the separatists, but they'd be under day-to-day fire of Ukrainian artillery and air attacks. And by way of answer, the separatists had anti-air war artillery, while the Ukrainians pounded the hill with airstrikes. Separatists deployed increasingly sophisticated anti-aircraft weaponry, downing several Ukrainian jets in July. That's what the official record says. I quote, "Despite the attacks," and we're still talking about 16 July, attacks on Samogilia, there were a large number of units of the Ukrainian army east of Marinovka and south of Dimitrovka had ended up in a defensive. They tried to cross the area south of Snitsa in a convoy and to move towards Mariupol. They were about to be cut off by other Ukrainian units and to be surrounded by other separatists. This action, however, fails, and part of the Ukrainian troops indeed was almost stuck in that area. Not only the Ukrainian troops on the ground were struggling with the separatist attacks, but also the Ukrainian Air Force was hit hard when two aircrafts were downed. And then we read, "The consequences of this fighting was that on the 16th of July, the villages of Tarani, Marinovka, and 3 high grounds were in hands of the separatists. And this led to the fact that at the end of the day, Ukrainian troops had been separated and that the corridor in the direction of the Russian border was almost controlled by separatists. On 17 July, the Thursday, these fightings continued. And as a consequence of Marinovka being conquered and the almost blockage of the corridor, the Ukrainian units tried to break through this blockage. And as a consequence of a massive Ukrainian campaign, the areas of Marinovka, Stepanovka were hard hit by artillery fire from the Ukrainians. And heavy losses would have been suffered by the separatists. And despite these losses, according to the news, the separatists held their ground. Ukrainian units came under fire from separatist positions. In the light of these developments, it is clear that the words in the conversation of 16 July 2011 p.m. that the book is their only hope should not be given the meaning and significance attributed by the public prosecution, because just before that, 2 fighter jets were successfully downed. I would like to highlight the following. In these losses suffered on the side of the separatists, with that, the official record has a footnote that refers to an information from Strelkov on 17 July 2014 at 12:02 noon. Regarding the losses suffered at that point in time, the bookteller, according to the prosecution scenarios, almost at Snitsnoy. According to the public prosecution, the bookteller would have been ordered the day before, 16 July 2014, somewhere in the afternoon. If that would be correct, the losses on 17 July 2014 cannot have been the reason to order the book tailor one day earlier. From the official record front lines, we cannot draw the conclusion that the separatists hardly had an answer for the Ukrainian airstrikes because they, for lack of their own air force. A second reason to assume that there was no need to strike fighter jets at high altitude is to be found in the circumstance that the aircrafts deployed by the Ukrainian Air Force, also in view of the many civil objects and targets on the ground that they didn't want to hit, they were carrying out precision bombings. And for that, it's necessary for fighter jets to fly relatively low when they start bombing, contrary to aircrafts that carry out so-called carpet bombing. We know the images of that from the Vietnam footage. In none of the statements made by pilots of the Ukrainian Air Force do we read that in this conflict they were carrying out bombings from high altitude. And so the question to the pilots was not focused on that specifically. All of a sudden we do see it as a motive in the public prosecution's address, but the investigation did not relate to this circumstance. There was no pilot that was specifically asked about this motive or this reason for shooting at a high altitude. And a picture of this carpet bombing has been included in my pleading notes. The partial conclusion concerning the motive of growing need. For the conclusive factual position of the prosecution that the Ukrainian Air Force tried to prevent the breakthrough to the Russian border by carrying out airstrikes from high altitude, for that position there is no evidence whatsoever. The follow-up position that as a consequence there was a growing need for heavier anti-aircraft weaponry with larger range is disqualified by the facts that I just mentioned, because they showed that there was a successful defense. Because of the precision bombing that had to be performed at low altitude, military speaking, there was no reason for an anti-aircraft system that could reach to much higher altitudes. And then there are conversations that were mentioned in the public prosecution's address, from which the prosecution infers that those aircraft needed to be struck at high altitude and that therefore there was a need for this weaponry. And this is what the prosecution calls a growing need. And in paragraph 110, I shall discuss those conversations. Because these conversations are really the only source of evidence that remains, and the interpretation of those conversations ultimately is not decisive. The summing up of facts and the way in which the separatists were gaining ground on the Ukrainian army on 16 July and was successfully defending itself against airstrikes, and also in connection with the fact that the aircrafts were carrying out bombings at lower altitude, that goes to show that the text translated from the conversations, insofar as they would imply that they were looking for weaponry in order to strike aircrafts at high altitudes, is something that we need to take with a grain of salt. And I shall highlight the most relevant conversations that were also put forward in the public prosecution's address. First of all, the conversation 16 July at 11:43. There's a phone call between two people, and the outgoing caller calls from a location in the Luhansk region. They don't seem to be DPR fighters, as the prosecution argues in its address. And furthermore, it seems that these are spotters, aircraft spotters, and they want to know who fired and where it was. One cannot infer from the context that the persons that have anti-aircraft weaponry when they call each other. The caller, who's located in the Luhansk region, sees the Shuska fly along at a high altitude, and then he says impossible to acquire it. So that must be somewhere in the Luhansk region. The prosecution interprets this sentence as follows, that it's very difficult to be able to strike that aircraft at that altitude. But it could also be linked to the fact that the aircraft is going around in circles, as we read in the next sentence. The question is, what do these two people who are talking to each other mean exactly? It could also be that they find it very difficult to properly spot the aircraft at this high altitude, or to be able to predict the behavior of the aircraft. The most favorable translation for the interpretation of the public prosecution of the word acquire is to obtain or conquer. And even if that were met in this sentence, we cannot understand this sentence as if these two unknown separatists that are exchanging information mean to say that they find it very difficult to strike aircraft at high altitude, and that they need anti-aircraft weaponry. You cannot just reach a conclusion that there was a need for artillery in order to be able to strike aircraft at high altitude. If that were the case, there would always be such a need, and not specifically on 16 July. But in its quest for a motive in the public prosecution scenario, all of a sudden this is considered to be an important factor. And I just pointed out that there is no witness that has been asked specific questions about this. In the next conversation on 16 July at 11:50 a.m., they say that Tsar Mogila was hit from high altitude, and the sentence is, look like it's hitting from 3 or 4 meters or so. 3 or 4 meters. Does that mean 3 or 4 kilometers altitude? And then the conversation of 16 July, 18:55 p.m. And here, the conversation is between Dubinsky and another person. And this conversation is full of code. And so we can hardly make head or tail from this conversation. And it's absolutely clear that they are speaking while realizing that their conversation is being intercepted. The number of casualties mentioned by Dubinsky in this conversation should be put in context of the misleading information given by Pulatov at 1812. He made a statement about this, and there's also part of the conversation in which they talk about casualties. If these are the real numbers, I would think that 2 months after this conversation, almost all militia fighters would have been dead. After that, Dubinsky, at some point in time in this conversation, says, I left in the morning and they started bombing the plane. That would mean that he left when the shooting started, and that he either heard from someone else what happened afterwards, or he himself just interprets as much. He then proceeds with the sentence, from as high as 7 kilometers or so. Is this his own interpretation? And what is this estimate of altitude based on? A conversation about 50 minutes later, at 1909, the 7 kilometers of Dubinsky all of a sudden became 5 to 6 kilometers. And furthermore, in this conversation, he explains in clearer terms, then I left, and after that, jets came along. So it's not his own knowledge. It could well be that the source of this information is the conversation of 11:50 a.m. that same day, but we don't know. So you cannot reach the conclusion whether there was just one piece of news that was then discussed by several persons, and then you get the so-called Chinese whispers, or that there were several separate pieces of information. Now, the first is the most probable. And then in this connection, the prosecution's address also refers to a conversation between Dubinsky and Pulatov at 18:12 on 16 July. This is a conversation in which Dubinsky calls the number that ends with 511. Before discussing the substance, I would like to determine that there's no evidence that Pulatov on 16 July was in touch with the participants of these conversations that I just mentioned just now. In other words, there is no proof of a connection between the information that was shared in these earlier conversations and the knowledge of Pulatov during this conversation at 18:12 p.m. The public prosecution tries to establish this connection by saying in the public prosecution's address the DPR fighters in several intercepted conversations on 16 July say that they're struggling with several high-altitude fighter jets and that it's very difficult to strike these aircraft. Wonderful summary, but the question is whether this fits what can be, in fact, derived from these conversations. The footnote to these conversations refers to conversations that Pulatov did not take part in and that I just discussed. And then the prosecution says the defendants also complain about this. And then in the footnote, there's reference to two conversations, the first of which takes place at 13:26 between Korchenko and the number 511. This is a conversation that is now known as the Broken Strela 10 conversation. This conversation does not refer to fighter jets flying at high altitude that are very difficult to strike. The link the prosecution tries to make between Pulatov and conversations about high altitude fighter jets lacks any factual basis. And then a later conversation that same day at 18:12 hours. And before I discuss what our client said about this conversation, first of all, I'd like to emphasize that the Dutch translation of this conversation doesn't provide us any information pointing to the fact that literally it was said that a fighter jet bombed from high altitude, because the translation says what is necessary is the long-distance artillery and a proper anti-aircraft system, because an aircraft is going at high altitude and practically no system could strike it. The question is, and this is not only a matter of semantics, Your Honor, the question is what we should exactly understand by this translation has been going on, and what exactly at high altitude means. I don't want to speculate about this, but I just want to point to the fact that this piece of information on 16 July is at odds with the information on this day that I just referred to when I referred to the official record front lines. Shows that the systems of the separatists were rather effective. But what is perhaps even more important is an overview made by the Ukrainian Air Force, an overview of aircraft losses, and this is part of the official the case file. We read in this overview that on 16 July 2014, at 19:10, 2 minutes past 7 p.m., an Su-26 M1 was destroyed by a guided missile at an altitude of 6,200 meters. If that information is considered to be reliable, then that is a very hard indication that the separatists were quite capable of striking fighter jets at higher altitudes. And it also goes to show that the misleading information provided in the conversation, according to Pulatov, immediately had an effect. About 3/4 of an hour after the conversation, 18:12 vis-a-vis 19:02, a fighter jet was struck at high altitude, 6,200 meters, whereas the Ukrainian armed forces, based on the intercepted conversation, may have assumed that it wouldn't be able to be struck at that altitude. It also goes to show that separatists didn't need a book, because that's the issue here, in order to defend themselves adequately. My conclusion concerning the interpretation of the conversations about high altitude is as follows. From the very few conversations that the prosecution has referred to in this connection, we, on the one hand, cannot simply infer that there would have been any bombing from high altitude, and hence there would be a need to strike fighter jets at high altitude with anti-aircraft artillery. And on the other hand, the military facts of 16-17 July show that in view of the effectiveness of the systems that were already being used, this was simply not necessary. And furthermore, in all these conversations, once again, it is relevant, and this is something not to be underestimated, that they were conversations held in war conditions, and they had a secondary purpose, namely to mislead the enemy. The substance of the conversations cannot be simply interpreted as a scenario that fits the prosecution's own scenario and can only have evidentiary significance if considered in connection with what the people taking part in these conversations had stated. And as we know, such an explanation simply doesn't exist, with the exception of my client's explanation.
Finally, the suggestion in the prosecution's address that the words in the Dutch translation of the conversation from 6:12 p.m., the words proper air defense system, the words that this would entail a book system, is incorrect. The word book was not used in this conversation. It was used in subsequent conversation at 7:09 p.m., to which Pulatov was not party. And specifically, that conversation was 7 minutes after, according to the Ukrainian Air Force, an Su-26 was taken down at an altitude of 6,200 meters. Client has stated the following, that there's a part of the conversation in which we described that the Strela 10 missile that we have available was presumably broken and not in working order, and that was to mislead the enemy. I won't read out the entire conversation. I'm simply referring to it. Let's see whether there's a section that I might need. Yes, he also indicates what I said about the precision bombings. You'll see that all in his statement, and with your approval, I'll continue at paragraph 80. Pulatov's interpretation of this conversation is now far more understandable in light of all the circumstances I described on 16 July. So the conversation of 6:12 p.m. does not mention a book, and also because of Pulatov's interpretation of this conversation, it cannot, as I'll discuss later on, it cannot be seen as the start date and time of the request for a book teller. I'll explain that in the timeline concerning a different subject, but that is exactly what the prosecution does in their address, where they see the words proper anti-aircraft system as meaning a book teller. But in the timeline of the prosecution alone, this does not match the chronology of events. And then in the course of 16 July, in its address, the logistic unit of the book teller is said to get on the move. According to the prosecution, it may be inferred from a conversation at 4:43 p.m. that Chernik had to bring 2 vehicles, which were believed to be the vehicles that would escort the convoy, including the book teller, the next day. According to the prosecution, this would suggest that even before the phone call at 4:43 p.m., the book teller, according to the prosecution scenario, must have been requested and committed, and that would not have been arranged in a few minutes. So this means that if that scenario would have been correct, the book teller would have been requested way before this mention of a book teller in the conversation at 6:12 p.m. with Dubinsky. So Pulatov was not the one who initiated bringing in a book teller. In addition, the case file indicates that the word book with respect to the scenario of the prosecution is first mentioned in a conversation between Dubinsky and Semenov at 7:09 p.m. So once again, not Pulatov. This was on 16 July. Dubinsky says, if I managed in the morning to get a book teller there, it would be nice, but if I do not succeed, it will truly be most unfortunate. First, it may be inferred from this that at 7:09 p.m., Dubinsky does not yet know whether he will succeed, which is at odds with the aforementioned timeline of the prosecution, which starts well before 4:43 p.m. In addition, when Dubinsky refers to over there, he means the place Grigorovka, which is also at odds with the prosecution scenario, because in that scenario, the book-tailor would end up in Performaisky. The first conversation with number 511, in which the word book was mentioned, was only on 16 July at 11 past 8 p.m., 11 minutes past 8 p.m. The conversation with Chernik, which, according to the prosecution, was the start of the logistic operation concerning the book-tailor, had then been 3.5 hours earlier at that point. Dubinsky calls number 511 and indicates which units will be operational on 17 July and which would go into reserve. Oleg's unit, as it says, is one of those units to be placed in reserve. The only response to Dubinsky's comment is consistently, aha, yes, clear, okay, and so on. Then, all of a sudden, in response to the question in that conversation as to where Python is, the response to Dubinsky's remark is, if a book is brought here tonight, then it will immediately go to you, with the very revealing addition, question mark? Because we don't speak Russian, I already emphasized this in prefacing our arguments, we are not in a position to assess, let alone grasp, the intonation of this conversation. But hasn't the translator added for a reason? Isn't that an addition that we would make with a wink if we were having a face-to-face conversation? The same may hold true for the addition after the sentence about the book being the only hope. Isn't it? Isn't it? And then the conversation concerns about the units which are to be made ready the next day, to be ready the next day. And regarding the term book used in the phone conversations, Pulatov, as you know, stated that he used that in an effort to mislead. And more specifically, he said if we were to use the book missile there, it would require special protection and additional guards, so additional manpower would have to be moved to guard the book, and that was not efficient because there was already a lack of manpower. On the other hand, we had other missile systems that were far more efficient and suitable for the type of target we were dealing with and threats that we were dealing with. And then he once again mentions the Strela 10 and says if you consider the characteristics of the book-tailor, they need to be operated at least 15 to 20 kilometers from the front line, as we said. Now, 89. If your court wishes to set this interpretation aside, then it's relevant to note with respect to the conversation at 8:03 p.m. that this translated sentence, then it will immediately come toward you, has various meanings, or can have various meanings. Does it mean that it will head in your direction, so to the region or area where you are? In light of previous conversations, I mentioned that would have to be Grigorovka, or does this remark mean that you'll receive it personally? With respect to the desired ownership, the prosecution prefers the last interpretation by asserting that the conversation is meant to mean that the book will head directly to Pulatov, which is not, according to the translation, what was literally said, and it could just, the words used could just as easily mean that the book will be transferred to the area where Pulatov was, and such alleged ownership is far from clear based on what happened the following day on 17 July 2014, for example, because Pulatov and his unit went in reserve and took charge there. I'll talk about that later on. First, the chronology of the conversation. The next conversation involving number 511, stated in the prosecution's address, was at 9:31 a.m. on 17 July. According to the prosecution scenario, the book-teller was in Donetsk by then with Pulatov had nothing to do with the entire logistic operation that the prosecution assumes. As for the conversation with number 11, where the word book was mentioned for the first and last time, that was nearly 13 and a half hours ago. In this conversation, Dubinsky is notified about the situation in Grigorovka and weapons available there, entirely in keeping with Pulatov's intelligence duties. Once the conversation has in fact ended, as you see more often in those book conversations, Dubinsky, entirely outside the context of the conversation, suddenly notes, listen, Krot will now bring you a book M. Hello? And the response is, once again, aha, understood. This needs to be positioned in Performaisky, and then after that, they say book M. The only alternative, the only answer is then yes, yes. I won't repeat what Pulatov said about these types of conversations, but it appears to perfectly match the transition to the book M, and also mentioning the place name and where it is stationed with the awareness that the enemy was listening in. It is not plausible that Pulatov took this remark seriously, because the enemy would immediately act if this information were correct. So Pulatov understandably saw it from that perspective, because he understood that the game of deception started the night before. It was simply being continued. Pulatov, therefore, was not truly dealing with a book, as the prosecution has asserted. Regarding the indication toward you, the same holds true as I indicated previously. The prosecution argues in their address toward him, Pulatov, whereas it could just as easily be a geographic designation. And which place is meant in that conversation, indicating Permomaiska, which was the literal translation, and that led to an additional report conveying something in there, says the speaker, that does not mention the current phone call, but other conversations in which both Perfumaskoye and Perfumaiska appear in the translation. So 3 ways of writing Perfumaisky. This report will need to be understood, first of all, as having a typo in the Dutch translation thereof, because in the conversation, what was said was not Permomaiski, but Pervomaiski. Since it's not entirely clear to the reporting officer either, he looks for a place designation that appears twice in close proximity and also looks near Snizhnoy. And he does this, he explains, given the phone calls previously mentioned. In these conversations in the report, however, Snizhnoy is not mentioned. He then generates a Yandex map in the report with 2 places designated. One cannot be the place appearing in the charges, because it's the name Perfumaiskiya, which is not the Perfumaiske. But as known from the case file, there are several villages with similar names in Ukraine and East Ukraine. Now back to the chronology from 17 July based on the prosecution's address. According to the prosecution, in a conversation that took place at 9:54 in the morning, Dubinsky was believed to have said that Pulatov would also come to the area of Pervomaiskoye. In that conversation, Pulatov's name was not mentioned, but there was mention of Jurza without an I, and that is not necessarily the same as Pulatov. The same holds true for the conversation at 9:55 a.m. as what I just argued with respect to the conversation at 9:31 a.m., so clearly mentioning book hello in a conversation that's to be intercepted, and once again mentioning the location where it would be stationed has understandably been perceived by Pulatov as not serious information but misleading the enemy. And it's not strange that the word book is mentioned in these conversations, because it matches the game of deception set up by Dubinsky and Kharchenko in the evening of 16 July and the morning of 17 July. Finally, two conversations from after the crash remain that involve phone number 511, in which the word book is mentioned. From Pulatov's perspective, once again, the term book does not have the significance now attributed to it. What matters regarding the evidence with respect to the evidence location of Pulatov, what matters is that if any value is attributed to what the speaker on the 511 line says in the two conversations at 6:44 and 7:52 p.m., this cannot be linked to Pulatov. That from this it may be inferred that he knew about deploying a book, because this is information provided to him after the crash, so it's information known only to the offender. Alternatively, if such knowledge can be assumed to have been his earlier, then from Pulatov, the 6 bullet points listed in the charges, they have not been proven. And this cannot be, mere knowledge is not one of these 6 points made. Now, my partial conclusion regarding book conversations. From Pulatov's perspective, in the conversations quoted, there was no actual mention of a book system, therefore the information is misleading. His attitude in the conversations is decidedly passive, and he does not use the term book himself. In the conversation at 6:12 p.m. on 16 July, one cannot infer the start date of allegedly ordering a book system, and Pulatov did not initiate that. Later on, I'll explain that from early June, this system was discussed, and Pulatov was not a participant in any of these conversations. Now, the final section for today, which had the title that Pulatov did not vary his statements. The prosecution's address also mentioned that Pulatov is said to have varied his statements about what he discussed and heard concerning a book. We have a different view. In February 2020, at the end of the video, Pulatov was asked a few general questions without sections from the case file being presented to him. The purpose of these questions was to have him indicate in a general statement whether he was involved in the offenses charged, and whether he actually, not in the sense of misleading information, whether he actually spoke about a book system, and his answer should be perceived in that context. At that point, the JIT had already published conversations in which, according to the JIT, Pulatov was a participant and the word book was mentioned. Pulatov was aware of this, as were we, via the ARVO provided to us at that time. So he was not surprised by some conversations that we played in his presence at that point. So that's why we decided to have the conversations from February added as well. At the start of his video statement, sections are shown from that initial video statement, and he's requested for comment. And he answers, yes, I merely want to repeat what I said at the time. The statement I made to you on 16 February was and remains the truth, but perhaps I should provide a bit of explanation about the communication devices used in the Donbass at the time. That's a fairly traditional device that's used and is known to all regular soldiers. We're well aware that the COM conversations we conduct are intercepted by our enemy, and that's why we deliberately used some phone calls to mislead our enemies. So if you hear something that's nonsense in the conversations intercepted, such as mentioning a book, you can be certain that the purpose was to mislead the enemy. We did not hear this explanation from him in the prosecution's address, but it does not appear that his statements varied. And this Monday, I will continue to talk about changes, and one important topic is change in command structure. And let's see, that will be number 113. It's not in this index here. Thank you very much. Thank you. Excuse me, because I assume you're going to close the investigation, but we have one more question based on today's arguments. So if you would allow me, so that I'm not too late with this. The annex we received was the report drafted by the Americans. There is no image of the area that they found. I do understand that it was visible on a video, and we would like to know whether the video will be incorporated in the file. And will that be provided with the digital version of the arguments? Yes, it's ready. I just need to see when the digital version, minus the sections that were not delivered, it's almost ready, but I need a bit of a weekend, so I will not start correcting the digital version before the weekend is over. So I don't know whether I'll get to that today, but you'll receive it. So Wednesday, we plan to show all digital items that we presented, and we'll have that ready for the court on one USB stick. Very well. That said, thank you. Once again, at the end of this week, I would like to thank everybody outside the courtroom as well, the technicians and the interpreters. We're now going to adjourn, and we will reconvene on Monday morning once again at 10, but that will be summertime because the weekend will be 1 hour shorter than we are used to. I didn't want to spoil your mood. I just want to make sure that we're all here at the right time on Monday morning. Have a nice weekend and a safe trip home.